Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. Whew. Sorry I am late. Sorry I am late. I was blissfully asleep. It was great. It is the old intro. We'll be back to the new intro tomorrow. Oh boy. Excuse me. Had a big day today. A lot of stuff to do. And took the kids to the beach. Went out to eat. Got ready to go back home, cuz that's tomorrow's chores to get back home. Oh my goodness. Have some things been happening? There have been some things happening. Gosh, I'm still getting awake here. I was out. I didn't think I was falling asleep. But there have been some things happening. Obviously, the Chauvin trial is still going on, and there will be some more clear coverage of that starting when I get back. But that's going on. There have been people getting kicked off of airlines. There have been people getting thrown out of Disney. Thank you. I am on top, chat. You're correct. There have been the things in the title. Okay, let's talk about the title. We have Twitter being moot. We'll explain that in a minute, but that is related to the Supreme Court and Donald Trump's Twitter case, which I'm not sure how the Supreme Court is determining mootness anymore in their decision making. It's very, very baffling because the Supreme Court is calling things moot that are not moot, that there's still real questions about. So that is a huge one. But they have determined that. Do you remember this? Heck, this case was actually decided when I was in Florida a long time ago, over 2 years ago. They had decided that Donald Trump blocking people on Twitter, that was a violation of those people's First Amendment rights. Which, if that sounds weird to you, it's because it kind of seems weird, because it's not really particularly preventing anybody from talking by blocking them. Okay? But the appeals court ruled that if Donald Trump blocked a journalist, that Donald Trump's Twitter account became a government place because he was a public official, and that the government property of Donald Trump's Twitter account was not allowed to block people, right? Very, very big decision, and very, very interesting. And one of the big questions is, how is this going to play going forward? Because we know that Joe Biden, for example, his White House is preventing any comments at all on the YouTube on the YouTube videos. They don't have a comment section. They turned it off. So a lot of people were asking, well, under this idea that Donald Trump is shutting down someone on Twitter, doesn't that make Joe Biden's YouTube channel, or the White House YouTube channel, doesn't that make that similarly a government place, and therefore can they shut it down? That's a question. Now, there's some differences there because you have a specific silencing of particular people on Twitter, but with YouTube, it's generally applied. So there's definitely a distinction, but we have the same underlying principles for the question. So that was a big question. Another place where this was going on was Twitch. The U.S. Army's Twitch channel was deleting comments and banning people for talking about their allegations of United States war crimes, for example, on the Twitch channel. And so there was a real question as to whether or not the U.S. Army could do that. Because again, here we have this idea. This is a government space. We have state actors and state actors silencing things. So anyway, it was decided again that Trump's Twitter account was a public space. It was not private, and that therefore the government had a duty to maintain access to that, to the place where that was able to. Well, today the Supreme Court refused to hear that case and declared it was moot and remanded it back to the lower courts to be dismissed as moot. And so that means that the appeals court decision that said it was illegal for Trump to block Twitter accounts is not a binding decision anymore. So, but here's the problem. It's not moot. It's not moot because Joe Biden or literally any politician can still block people on Twitter. And the question is, are they allowed? Like, the controversy is still there. And if the controversy about whether or not a politician can block people on Twitter is only obviated because Trump's Twitter account no longer exists because Twitter deleted it, then Twitter has the ability to avoid any lawsuit merely by suspending or deleting the account in question. Doesn't make any sense to me. That doesn't make any sense. So that's something we're going to look at that opinion today. Now, for the most part, that opinion was nothing. There was no opinion. There's no reasoning to it. They just said it's moot. So it needs to be remanded back to the lower court with instructions for them to dismiss it as moot, which renders the previously binding decision of the appeals court to be not authoritative anymore. Which might be a problem because I believe that some cases have actually relied on that decision. So that's that. However, Clarence Thomas has written a concurring opinion. He has concurred with the conclusion that it's moot, but he had some things to say about it. So we're going to look at that. That is just very, very baffling decision by the Supreme Court. I have a feeling we'll find out why Clarence Thomas should be Chief Justice pretty soon. But hey, that's what it means with Twitter is moot. Sorry to ramble through that, but it's going to be a big part of the show, and just explaining where all that comes from took a little bit of doing. But next part of the show, some guy in my comments is a moron. I mentioned this guy the other day, but he continues to be stupid. And that's a frustrating thing because, like, look, there are lots of good questions that come in the comments. And there are lots of bad questions that come in the comments. And sometimes when it's all a product of math and fate. Like when I happen to get a notification or I happen to be looking through a particular comment section, I happen to see a comment that stands out, and then I happen to respond like that. That's what goes on. And then sometimes I get notifications on, when people respond to me in comments, and other times I really don't. So it's a mixed bag of that. But I've got one, and I'm gonna pull it up, and we're just gonna kind of walk through it because this guy's been driving me nuts. He's so dumb. And the reason I answered his initial question is because it wasn't a dumb question at first. It was a fine question. He was just on the wrong track. And so I tried to just, very, basically answer the question. But then it's now grown into this nonsensical theory. It's about Kyle Rittenhouse. So we're going to go through that. And I want to use it to talk about some of the things this guy is claiming about Kyle's case. And we're going to go through this because just some very, very big misconceptions about how self-defense works, about what your rights are, and all that stuff. And it occurs to me, by the way, the person's YouTube name is Simon Says. So maybe it's a giant troll job. I don't think so. I think this is a true believer. Bmons says there are no stupid questions. Au contraire, my friend. Despite what your elementary school teacher may have told you, there are lots of stupid questions. Lots of stupid questions. And this person asks many of them. So we will be looking at that very soon. So that's the other part of the show. And then the other thing is Rip Alex Jones's Newtown lawsuit, which I apologize that the Twitter message truncated that as Rip Alex Jones. I hope no one thought Alex Jones was dead. He is not. He is not. Thank goodness. Thank goodness. He is the most memeable man on the planet. A veritable teddy bear of, a tinfoil hat wearing teddy bear of manhood. He's hilarious. And whenever he eventually is gone, he'll be taken too soon. He'll be taken too soon. So, however, his appeal to the Supreme Court was also denied. So we'll be talking about that. And then there's just some little, stories in there as well. So that's the show I have for you. That's what I have for you, and we're gonna go through that. I do not think I will be able to do a Twitch show tonight because I have to get up early in the morning. So that's that. That's where we are. So we'll have to we'll have to just deal with that, I guess. Let me get these early chats that came in before the show started, and then we will get into the topics. All right. Oh, by the way, big thank you to everybody who hung out with me on Easter last night. That was nice. A good show, a good fun time. I hope you enjoyed it. Drinking Coke. Yeah, well, that's what's here. That's what's here. What? Man, my brain My brain is a jumbled mess. Okay, let's do this. Oh, that's what I'm looking for. This one, 200 watts. Okay. I had to find out where this was. Andrew War Snowboard says, thanks for all of your prayers for me yesterday. I feel 100%. I haven't got my test results back, but I don't think I have COVID. You have the best fans. Well, I know I have the best fans. I know. That's why I hang out with them every night. Funny Valentine 2024 says, yo, Nick, since you're the Minnesota lawyer, can you provide clarification on the lack of merger doctrine in Minnesota? Barnes and Nate were discussing it through Viva, bless his heart, in relation to the Chauvin case. I mean, the felony murder statute in Minnesota is pretty straightforward. If there is a felony and someone dies during the commission of that felony and the death was not intentional, then it is felony murder. It's not rocket science. That's how the law is written. I know other states, I guess, have a different read of that. They have the merger doctrine, which is where when an element of a higher criminal offense is an element of the lower criminal offense, when it's the same element, they get merged together and you only charge the higher offense. In Minnesota, that, I mean, they kind of do that. That's why it's a felony murder rather than a battery in this case. But yeah, it's, I don't know how else to explain it. The language of the text is very clear. Nate pointed out that aggravated assault, I believe, is sufficient for felony murder under second degree in Minnesota. I don't know how other states word their statutes, that they do it differently, but you got to remember, this is the crime is there's a felony, and the felony itself causes an unintentional murder, or a death occurs during the felony and the death is unintentional. That's the second degree statute. And in that case, if you have a battery, a felony battery or a felony assault, I think Minnesota calls it an assault or assault and battery. It doesn't really matter. If you have an underlying felony, someone dies during it, and you didn't intend for them to die, then there you go. You have felony murder. If you intended for them to die, it's a different charge. Or it could be second degree still, but it's a different charge under the same statute. This is a different section of the statute. So, I mean, off the top of my head, that's the basic gist of it. Again, I know, I don't think the merger doctrine applies in this case because Chauvin isn't charged with the underlying felony. He doesn't have to be. The underlying felony is the basis for the murder. It's just the difference is that someone died. So anyway, but here's the thing. Nate appears to be right on that, and that's fine. None of us lawyers know any or all aspects of every law everywhere. And so it's okay to know how one thing works in one jurisdiction and have it work different in a different jurisdiction. That's a perfectly acceptable thing. And yeah. So there you go. I don't know what else to say about it, but that's the basic gist. We can look at the statute in a minute if you want, and I'll show you. Funny Valentine says, also enjoying Twitter R-tards simping for corporations. Both angry at recent Georgia voting bill. Confession through projection, they're the real racists. Well, yeah. This whole thing where people are like, no, corporations are free to do anything they want. I had a big rant about this. Wasn't it yesterday? Was it yesterday or the day before yesterday? I had a big thing about how this is going to be the new sort of question. And actually, Thomas talks about it today. Thomas talked about it today, I believe, in this opinion that we're going to read. I haven't read this opinion by Thomas, but I've seen a couple clips from screenshots from it. And he raises this idea that there are limits to private businesses that are open to the public and who they're able to keep out and why. Like that, and these limits are not new. It's not some weird thing that we're putting on to social media or something. This is how it's done. He talks about the common carrier doctrine. I don't know if he goes into the idea of a public accommodation, but these things are not new. They're not special for social media. In fact, the only special thing is that social media hasn't been subjected to them at all. But if you want to test the limits of this yourself, I don't recommend it. Open a restaurant and say, we will serve everybody except Arabic people. There you go. It'll be very quick that you find out that you are not just a free public business, the private business that gets to make its own decisions about who you serve. You can't do it. You can't do that. And that test could be coming to Twitter very soon and coming to somewhere else. Anything else. The question is, what is protected? How far does it go? And, are their policies disparately impacting? Are they disparately applied to protected classes? The Pedicab Avenger, you are not the moron in my comments, I don't think. Sauce says, what do you think of Viva saying, I think he's guilty? I just don't know of what? What, Chauvin? There's a whole lot of theories under which Chauvin is guilty of something. I don't think he's guilty of second-degree murder. I think the third-degree murder charge is a better murder charge, but that doesn't mean it's the right charge. I think the manslaughter charge has a lot of potential, the second-degree manslaughter charge. It means he negligently created a situation that had the ability to cause and did cause the death of another person. So, I mean, that doesn't mean he's necessarily guilty of that too, but we've got a lot of testimony about how he's broken protocol, about how he's done all these things. The question is he guilty of something? Did they overcharge? I don't know. We'll have to see. We'll have to see. That's what juries are for. And you can have a gut feeling about something and still, the person could be not guilty too. That's fine. Like I've watched that Chauvin and Floyd video, a million times. And every time I watch it, no matter what facts I know about everything, says to me, this situation is wrong. I get the overdose, I get the fentanyl, I get all those things. I get it, but I still look at it and I go, in spite of all that, Chauvin's on this guy for too long. It just feels wrong to me. And it has nothing to do with race. It has nothing to do with anything like that. It's just the simple fact that I look at these interactions between cops and citizens and I go, my basic gist of this is I don't want someone dead at the end of the day. And when I see someone die from a situation that feels like it could have gone way different, something rings wrong to me. That doesn't make him guilty, by the way. And that doesn't mean that he deserves prison. That's why I always say, these are my opinions on certain issues, and I will tell you my opinions on the legal issues, and I'll try and keep those as distinct as possible. Right now, every time I watch the Chauvin defense attorney, he's doing a very good job. a very good job of picking apart the testimony of the witnesses. The real testimony, the real problem is going to involve, or I shouldn't say the real problem, the real drama is going to involve the medical experts, how their medical expert testimony comes out, and how the defense team plans to tackle that expert testimony. And if they can convince the jury that the medical experts in their testimony are mistaken or are not correct or are biased or whatever they are, that's what they have to do. Those are the big that's the big drama of this whole thing. They have, I believe, 5 medical experts that are going to all testify of what was and wasn't the cause of Floyd's death. And the defense attorney's job is to cast doubt on each one of their testimonies. If they can do that, then, if they can say nothing Chauvin did was the cause of death, they can raise that doubt that something else was the cause of death, not a cause. That's important. If Chauvin is the cause of death and overdose is the cause of death, Chauvin goes to prison. That's the law. That's how it goes. You may not agree, and that's fine. But if Chauvin and the overdose are the cause of death, Chauvin goes to prison. If the overdose is the cause of death and Chauvin happened to be there, but the overdose is the cause of death, then Chauvin walks. That's the law. That's how it goes. So it's, I think I understand Viva and where he's coming from, saying, that he thinks he's guilty of something. I get it, because I look at it and I go, this whole situation is wrong. It's a bad situation. And there are lots of cases that involve cops that just end up being just a bad situation all the time. And if you were in the same situation as that cop, it would not be a bad situation. It would be murder. That happens a lot. Okay. And we defer to cops a lot on that. And I have a problem with state authority. And so that's what rankles me on that. If Chauvin walks, how long till a vigilante takes him out? If I were Chauvin and I defeated this case, I would leave the country immediately. I have a joke that I can't say. Go somewhere where you can kneel on everybody. No, I would leave the country immediately. The guy's life is over in the United States. Similar to like with Zimmerman, right? But yeah, we'll have to see. We'll have to see. There's today, the defense team brought up some pictures and got the police chief to admit that at least for some of the time, Chauvin's knee was not on Floyd's neck. And that's a big admission, right? That it could be on his shoulder or back, I think is the statement from the police chief. And so then the question is, was that knee appropriately applied? Was that knee the cause of death? Was in the situation, if it's not on the neck, these are the ways they're raising doubt. And that's interesting stuff. So we'll see how it goes. These are all the things. The problem is, again, it's going to come down to medical examiners. Medical examiners, to my knowledge, did not find that Floyd died of asphyxiation. They did say that the cause of death was the compression from the knee of Chauvin. They said that was the cause of death. Again, like the examiners or not, it's not really, doesn't matter whether or not we like the opinion. The point is that's the medical opinion, the expert testimony that's going to come in this case. And a heavy reminder that they have a toxicologist medical expert who will be testifying, and you can assume that the toxicologist is going to say that the cause of death in George Floyd was not an overdose. So again, whatever your opinions are, whatever your read of the toxicology report is, I get all of that. I'm not arguing with you at all. I'm telling you where the state is going to have their strong arguments. And if the state is calling a toxicologist medical expert, you can guarantee that that toxicologist medical expert is probably not going to get up there and say, oh no, he died from an overdose. Like, that doesn't make sense for the state to call that expert to give that opinion. So you've got to ultimately overcome the medical expert testimony, and it's really going to depend on what they say. That's going to hinge the entire case is going to hinge on that. 78 Swilly says, for the first and last time, fuck off. Why? What's making you upset? What's up? What's up? I don't get it. I don't know what made you mad, but that's okay. But anyway, so that's going to be the big part of the case. So all of the arguments about what everybody saw, these are all interesting exchanges. I think it's really good. There's a lot of really good lawyering going on, but at the same time, it's going to be what the experts say. So, all right. That being said, where are we now? Oh my gosh. My YouTube window is moving at the speed of death. What is happening? Hold on. I got to get rid of some of these windows. Why? Please. Sorry, my super chat window is all messed up. I'm going to try and fix it real quick. Watch me break the entire stream. I'm hoping not. Oh, I hate you, YouTube. I hate how you do this now. All right, this is going to be a effing mess. It went ahead and messed with all my super chats when I did that. So give me just a minute. Just a minute. Okay. Nova Zero says, stupid questions only exist for lawyers because all lawyers are automatically stupid. Like, seriously stupid. There's really dumb, then there's stupid. Lawyers are stupid. Everyone else, no stupid questions, just stupid people. Pseudo Snark says, share Barnes's concern. How can you have a manslaughter under the law then? Wouldn't all manslaughter be murder? No. No, it's a completely different scenario. This wasn't really in the plan. Falling in love was never part of the plan. All right, let me see if we can do this way. We'll try and see if we can look at this real quick. Just these two statutes, manslaughter in the second degree and second degree murder. They have different elements. I'll show you. I will prove it. Do we have it? Oh, pretty good. Pretty good. All right, so here's manslaughter in the second degree. A person who causes the death of another by any of the following means is guilty of manslaughter in the second degree and may be sentenced to imprisonment for not more than 10 years or to a payment of a fine not more than $20,000 or both. All right, it's the first one. By the person's culpable negligence, whereby the person creates an unreasonable risk and consciously takes chances of causing death or great bodily harm to another. Okay. So that is culpable negligence. That is not the same if we go to murder in the second degree. Unintentional murders. Here we go. Causes the death of a human being without intent to affect the death of any person while committing or attempting to commit a felony offense other than criminal sexual conduct in the first or second degree with force or violence or drive-by shooting. Okay. This is different than culpable negligence. This is a felony crime of intent, just not an intentional death. Okay, so not an intentional killing, but a crime of intent that is a felony. So you've got, again, if you want to go back to assault in the first degree, whoever assaults another inflicts great bodily harm, may be sentenced to imprisonment for not more than 20 years. So that's great bodily harm. Or assault in the second degree is assault with a, let's see, that's with a dangerous weapon. So that one doesn't account. Third degree, substantial bodily harm. Whoever assaults another inflicts substantial bodily harm, may be sentenced to imprisonment. So these are crimes of intent. You're trying to, you have to intentionally assault someone and inflict the bodily harm. All right. Fourth degree is, I think, related to peace officers. Yep. So that doesn't matter. So it's either third degree or first degree assault. Serious bodily harm, great bodily harm. It doesn't really matter which one. Those are both intent crimes. You're intending to cause the harm. You do cause the harm. The harm ends up causing the death. You go to second degree murder. Unintentional, but you've committed a felony. Now, it doesn't just apply to assault, but it happens with assault. It can also happen with, other sorts of felonies. Let's see. Well, heck, sex trafficking crimes, for example, right? Like if someone is sex trafficking a person and then someone ends up dying. Say the John ends up dying, right? During the unlawful sex trafficking. Whoever's responsible for the trafficking can actually be charged with felony murder. They didn't want the John to die, right? They wanted to collect their $85 or whatever it is and move on and traffic some more people because they're like, I like traffic. Traffic's good. That's what they say. And so then they don't want the Johns to die. They want the Johns to traffic again. But if the John dies, then, or if their trafficked person dies, they could be guilty of felony murder, even though they don't have any intention of killing them. So felony murder just requires some underlying felony. Culpable negligence doesn't necessarily have a felony. There's no felony requirement. In fact, it takes away most of the felony crimes because most of them require intent, not negligence. Some of them require recklessness, for example, as well. But this is a crime of negligence. Negligence is duty, breach of duty, causes harm, and then damage. That's the basics of negligence. So the question in manslaughter here is, did Chauvin owe a duty to George Floyd? Did his culpable negligence, did he breach that duty? Did that cause harm? And is there damage that was caused, but is it the proximate cause of the harm, I should say? And then is the harm amount to damages would be the other question. Well, yeah. So the question is, did Chauvin owe some duty to Floyd, and did he breach that duty? If he did, culpable negligence. Don't know, right? We don't know if he had a duty to him that he breached. But if he assumed a duty where he fails to administer a proper level of care because he's an arresting officer, for example, then he's created, through his culpable negligence, an unreasonable risk of death. And then by failing to administer that care, if he's breaching the duty, then he's guilty of manslaughter. So it's a separate crime. It's a separate criminal act at that point. And the elements are wildly different between manslaughter in the second degree and, second degree murder. So I hope that explains things. I know it does get confusing. I get it. And it's all, and especially because the different degrees of assault and manslaughter and murder mean different things in different states, but this is how the Minnesota law is written. And when you start to look at the Minnesota law, it's not super complicated, really. Like it's pretty straightforward. But I hope that helps. Where were we? Tina says, WTF, Nick, why did you kill Alex Jones? If I had that kind of power. If I had that kind of power, do you think I would be here? I would. I would still be here, but I don't. I don't have the power to end that man. Shade 221, the prison time for felony murder is the same as second degree because felony murder is second degree murder in Minnesota. I think it's up to 20 years or up to 25 years, something like that. Okay. Socialism is for Fig says, Nick, why does a court get to throw 3 different charges at the wall like spaghetti to see what sticks? Shouldn't it be a one charge thing? I mean, how does a guy commit 3 different types of murder on one person? The reason they get to do that is because they get to attempt to show factually any one of those things. They say, we've got a set of facts. It's one of these crimes. And we can show beyond a reasonable doubt that it's one. What they can't do is convict on 2 of the same crimes for the same elements. So that's the thing. They can't convict, I don't believe, on I guess in theory they could convict on manslaughter and one of the murders. I guess. It'd be a weird conviction. Let's cross that bridge if we get there. I don't think that's going to be the case. I think if they get a conviction, it's going to be manslaughter too at this point. I think that's the only conviction that they can make stick. And they are, I mean, that's part of the testimony that they've got where he violated procedure and all this stuff. That's what they're gearing towards there. But yeah, I don't know that we're going to see a conviction on both counts. So, but they get to, I mean, they can charge with whatever they have probable cause to show. They have probable cause to show that he murdered. They have probable cause to show the manslaughter. One of them or neither of them is correct. All right. Next, we've got the gray one. It says, evening, Nick. My wage cage is broken for 16 hours. I have a legal question. What is the difference between third-degree murder and second-degree manslaughter? To my knowledge, both are unintentional ending. I had to censor because Comrade Susan. Okay, third-degree murder is a little bit different. then second degree unintentional, and between second degree manslaughter. They're all unintentional. However, third degree murder is a recklessness standard, not negligence, right? Negligence means that you have a duty. Yes. Negligence means you have a duty and you breach that duty. Recklessness means that your actions recklessly put someone else in danger. Not that you have some sort of duty to stop them, but that your actions are so inherently dangerous to others that you don't have to owe them a duty for you to be for your damage to be bad. Like, you don't have a duty of care to anybody in a crowd, but if you fire a gun into a crowd, not aiming at anybody, you just close your eyes and fire in the direction of a crowd, then that's such a reckless act that you don't need to owe any of those people a duty. Your act is so inherently dangerous. That is where third degree murder comes in. So it's still unintentional. You may not want to hit, you may not even want to hit anybody. You may not want to kill anybody. You're just throwing 3-pound rocks off the freeway, right? You don't owe a duty of care to any car driving past, but if a 3-pound rock happens to go through the windshield of a car going 60 miles an hour, it could kill the driver or a passenger very, very easily. And so you don't owe them anything. You don't owe some special obligation to those people. However, that's just a reckless act and if it causes the death of someone. This happened in Minnesota with a pumpkin. So people threw a pumpkin off an overpass, and it went through the windshield of a car and killed someone. That would be, a type of third degree murder. Although I guess it's possible that could end up being second degree too, depending on if that was an underlying felony. I don't know that it was. Read third degree murder section B and tell me about Floyd's dealer. If George Floyd, I don't have to read it. If George Floyd overdosed and the overdose is the cause of death and they knew who dealt him the fatal dose, then in theory they could charge his dealer with third degree murder. Yes. That's a Minnesota thing. That is a charge I absolutely disagree with personally. I do not think that someone who sells someone else a controlled substance, which is a crime, by the way. It is a criminal act for them to sell a controlled substance, but then the person takes too much of that substance and dies. I don't think that the dealer should be guilty of third degree murder. I think that's a bad law. I think that's a very, very bad law, actually, because you have an intervening act of taking the drugs. So that's a weird Minnesota law. I hate it. I think it's a really bad law. One Angry Weeb says, I'm behind, but dear Lord, SCOTUS is a real fan of that moot ruling. Does SCOTUS even make rulings nowadays? Some, I guess. I guess. M. Wilson says, is excessive force a breach of duty? No, excessive force would be, that would be an underlying felony. That would be the felony assault. So that's not a breach of duty. So you have three main theories in the Chauvin case, right? Excessive force, that's second degree murder. Reckless disregard for human life that creates a risk, a reckless act that creates a risk, that's third degree murder. And then the fourth degree, or the second degree manslaughter, would be a negligent act that creates an unreasonable risk of, that causes the death. A negligent act that causes the death, which would be something like a breach of duty of care. Because again, if Chauvin and the other cops are in control of Floyd, then like he's got handcuffs on and stuff like that, then he's in custody if they have made the apprehension he's in custody and they find that, the jury would have to find that, then they have assumed some level of a duty of care at that point. And then the question is, did they breach that duty of care? If he's overdosing, did they fail to administer Narcan, or did they fail to administer proper first aid techniques? Did they fail him in that way? Did they assume the duty and fail him? That's third degree or second degree manslaughter. So those are the three basic avenues to each of the charges. So socialism is for figs says, Nick, could they charge Chauvin with no jail and a $1 fine and say, well, they got 27 million anyway and screw the state being paid? No, that would be a downward departure from the sentencing guidelines, and downward departures they have a legal justification that's required. And that Chauvin doesn't seem to meet any of the qualifications for a downward departure that would be that significant. Long story short, no, they can't do that. Okay. Oh my gosh. Now that we are this far in, Sam says, on the third degree murder for a drug dealer, what if the drugs were laced? Second cousin of mine died from heroin laced with fentanyl. Her dealer was charged with murder. Can't remember what level. This is in Wisconsin. Opinion on that? Look, I think that's a little different. I think if you have, and it depends on the knowledge of the parties and if you can prove that the dealer was lying or whatever. But if the person wanted heroin laced with fentanyl, I don't see how the dealer's culpable then. Dealer says, hey, this is heroin laced with fentanyl. Is that what you want? Yeah, that's what I want. I want that good stuff. And then they die from taking too much of it. I don't see how that's the dealer's fault, but I guess that depends on what you can prove. I'm also not familiar with the wording of the statute in Wisconsin. In Minnesota, though, it's any overdose. Any overdose goes back to the dealer. So laced or not laced. How does it work with prescription ODs? Do you think they're going to, a doctor lawfully prescribes something and someone ODs on it? They're not going to prison ever. They had a lawful ability to prescribe something unless they can show that the prescription was, some sort of, improper prescription, right? Like they were just prescribing it because it's their friend. Like, oh yeah, I'm a pediatrician, but I write fentanyl prescriptions all the time for my buddy. That's a little bit different, but they would have to prove that out. Okay. Let's get to this Twitter case. Let's see. Supreme Court. And yes, I was on a Project Veritas video today, which is very cool. Very cool to be in there. Is them talking about their New York Times case, and Project Veritas threw a couple seconds of my video in there. I very much appreciate that. I think that's awesome. Okay, let's find Thomas's opinion. Let's see. Here we go. And as I get back home, I'll be reaching out to Project Veritas. I think it'll be, I would love to get James O'Keefe on the show, even if it's, I don't know if he could do like one of these live streams or whatever, but even if I could get him on for like a 30-minute interview that I could air, because I think they just do phenomenal work. I think they're like truly investigative journalists. And in a time when we really don't have a lot of actual investigative journalism going on, and what they have to deal with the media and the constant smearing from the media is something pretty interesting. So I'll be reaching out to see if we can set something up. Again, I can't, it's up to them. It's up to them. Now they'll go after me. They already do. It's okay. But in case they do go after me, ricadalaw.locals.com. You can find me over on locals, ricadalaw.locals.com. Blah, 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 big spiel about how YouTube is on their purging streak again. Make sure you get subscribed to all of your people, because YouTube might have unsubscribed you yesterday, and they may do it anytime over the next couple weeks. They're doing their thing where they do unsubscribing waves, and they will remove your subscription from various accounts. So make sure you check it out, because they do this every now and then. One of them happened yesterday. It was boom, 180 subscribers just at one specific point in the day. They went away within 1 second. It was a YouTube thing. It's not. I've investigated these so many times. It's not a bunch of people all choosing to unsubscribe. People do that. People do that from time to time, and that's fine. YouTube does it in big batches, and they tend to do it at a consistent time at night. And they did one yesterday. So Yellow Flash talked about it. Some other people talked about it as well. It's a real thing. Just make sure you're still subscribed to the people that you like. If you like me, for whatever reason, do that. But make sure, your other channels that you're subscribed to, that you still are. That being said, to avoid that, just go to ricadalaw.locals.com. You will always, always, always get an alert, a notification when a live stream is going to happen. So if you want to make sure you don't miss any live streams, you want to make sure you get that notification with a link to it, go to Locals. Okay. Oh, it's free to follow me there. If you just want the notification, do it. Do it. All right. So here is the case. It's now titled as Joseph R. Biden Jr., President of the U.S. versus Knight First Amendment Institute at Columbia University. So the petition but it was Trump. He's just no longer president, right? The petition for a writ of cert is granted, judgment is vacated, and the case is remanded to the U.S. Court of Appeals for the Second Circuit with instructions to dismiss the case as moot. So here we go. Here is the important part. Justice Thomas is concurring in opinion, but we're going to see what Thomas says about this stuff, because this is, I think Thomas is the judge to watch. He's been aching for some of these social media cases to come in. He's been aching for it. When a person publishes a message on the social media platform Twitter, the platform by default enables others to republish, retweet, the message or reply to it or other replies in a designated comment thread. The user who generates the original message can manually block others from republishing or responding. Donald Trump, then President of the United States, blocked several users from interacting with his Twitter account. They sued. The Second Circuit held that the comment threads were a public forum and that then President Trump violated the First Amendment by using his control of the Twitter account to block the plaintiffs from accessing the comment threads. But Mr. Trump, it turned out, had only limited control of the account. Twitter has permanently removed the account from the platform. Because of the change in presidential administration, the court correctly vacates the Second Circuit's decision. I don't think that's correct. Personally, I really do not think that that's correct. I write separately to note that this petition highlights the principal legal difficulty that surrounds digital platforms, namely, that applying old doctrines to new digital platforms is rarely straightforward. Respondents have a point, for example, that some aspects of Mr. Trump's account resemble a constitutionally protected public forum. But it seems rather odd to say that something is a government forum when a private company has unrestricted authority to do away with it. This is interesting, right? This is the challenge that we have to deal with. Are they private or are they public? Supreme Court hasn't answered this. The disparity between Twitter's control and Mr. Trump's control is stark, to say the least. Now, that doesn't mean, by the way, that they should have the control. That doesn't mean that they should have control, even if they do. And it doesn't mean that the court will allow them to maintain the control if the right case comes forward. Mr. Trump blocked several people from interacting with his messages. Twitter barred Mr. Trump not only from interacting with a few users, but removed him from the entire platform, thus barring all Twitter users from interacting with his messages. At the time, Mr. Trump's Twitter account had 89 million followers. Under its terms of service, Twitter can remove any person from the platform, including the President of the United States, at any time for any or no reason. This is not the first or only case to raise issues about digital platforms. While this case involves a suit against a public official, the court properly rejects today a separate petition alleging that digital platforms, not individuals on those platforms, violated public accommodation laws, the First Amendment, and antitrust laws. So here's what I was kind of talking about with the public accommodations. The petitions highlight two important facts. Today's digital platforms provide avenues for historically unprecedented amounts of speech, including speech by government actors. Also unprecedented, however, is the concentrated control of so much speech in the hands of a few private parties. We will soon have no choice but to address how our legal doctrines apply to highly concentrated, privately owned information infrastructures such as digital platforms. And there it is. This is Thomas's warning. They're going to have to address it. It's coming. He's looking for the case. On the surface, some aspects of Mr. Trump's Twitter account resembled a public forum. A designated public forum is property that the state has opened for expressive activity by part or all of the public. Mr. Trump often used the account to speak in his official capacity, and as a governmental official, he chose to make the comment threads on his account publicly accessible, allowing any Twitter user, other than those whom he blocked, to respond to his posts. Yet the Second Circuit's conclusion that Mr. Trump's Twitter account was a public forum is in tension with, among other things, our frequent description of public forums as government-controlled spaces. Any control Mr. Trump exercised over the one account greatly paled in comparison to Twitter's authority, dictated in its terms of service to remove the account at any time for any or no reason. Twitter exercised its authority to do exactly that. Because unbridled control of the account resided in the hands of a private party, First Amendment doctrine may not have applied to respondents' complaint of stifled speech. Citing Manhattan Community Access Corp. Versus Halleck, a private entity is not ordinarily constrained by the First Amendment. Whether governmental use of private space implicates the First Amendment often depends on the government's control over that space. For example, a government agency that leases a conference room in a hotel to hold a public hearing about a proposed regulation cannot kick participants out of the hotel simply because they express concerns about the new regulation. But governmental officials who informally gather with constituents in a hotel bar can ask the hotel to remove a pesky patron who elbows into the gathering to loudly voice his views. The difference is that the government controls the space in the first scenario, the hotel in the latter. Whereas here, private parties control the avenues for speech, our laws typically address concerns about stifled speech through other legal doctrines, which may have a secondary effect on the application of the First Amendment. If part of the problem is private, concentrated control over online content and platforms available to the public, then part of the solution may be found in doctrines that limit the right of a private company to exclude. Historically, at least, two legal doctrines limited a company's right to exclude. First, our legal system and its British predecessor have long subjected certain businesses, known as common carriers, to special regulations, including a general requirement to serve all comers. Emphasis on the comers. Justifications for these regulations have varied. Some scholars have argued that common carrier regulations are justified only when a carrier possesses substantial market power. Well, I mean, does Twitter? Others have said that no substantial market power is needed so long as a company holds itself out as open to the public. Also Twitter. Quoting this 1850 case, a person who holds himself out to carry goods for everyone as a business is a common carrier. And this court long ago suggested that regulations like those placed on common carriers may be justified, even for industries not historically recognized as common characters. Or common carriers, when, quote, a business by circumstances and its nature rises from private to be of public concern, affirming state regulation of fire insurance rates. At that point, a company's property is but its instrument, the means of rendering the service which has become of public interest. This latter definition, of course, is hardly helpful, for most things can be described as of public interest. But whatever may be said of other industries, there is clear historical precedent for regulating transportation and communication networks in a similar manner as traditional common carriers. Obviously, imagine if phone companies could just say, well, I don't want that person to have a phone line because they're a Nazi. Have you noticed that hasn't really happened? That hasn't really happened that much. Not that we've heard of, right? We don't see ISPs refusing services in the way that banks do, for example. We don't see ISPs individually blocking people in the way that Twitter does. So that's an interesting sort of question here. Communication companies are typically common carriers. When do these services like Twitter and Facebook become communication companies by legal definition is part of the question there. Telegraphs, for example, because they resembled railroad companies and other common carriers, were bound to serve all customers alike without discrimination. In exchange for regulating transportation and communication industries, governments, both state and federal, have sometimes given common carriers special government favors. For example, governments have tied restrictions on a carrier's ability to reject clients to immunity from certain types of suits. Well, here, let's read the footnote number 2 first, which I skipped. It says, this court has been inconsistent about whether telegraphs were common carriers, but the court has consistently recognized that telegraphs were at least analogous enough to common carriers to be regulated similarly. And number 3, telegraphs, for example, historically received some protection from defamation suits. Unlike other entities that might retransmit defamatory content, they were liable only if they knew or had reason to know that a message they distributed was defamatory. Okay. So immunity from certain types of suits, or to regulations that make it more difficult for other companies to compete with the carrier. So by the way, telegraphs have had immunity, right? Like CDA Section 230 immunity. And this is really interesting. They had a similar immunity. You're immune to defamation as long as you don't know that it's defamatory. How would you know something's defamatory? A court order, right? A court found this to be defamatory. Other than that, how do you know? So they get immunity from transmitting defamatory content similar to Section 230. But the interesting thing with telegraph companies is that they had to service everybody in exchange for that immunity. And by the way, notice in the Communications Decency Act, it's the content that gets removed, not the content creator that gets removed. Maybe we should talk about that at some point. That CDA 230, and maybe that's a distinction that that lawyers and parties need to go after. CDA 230 talks about removing content, not removing access to the service. Those are very, very different things. Because if Twitter just said your tweet is bad because it contains something that violates our terms, it's objectionable, your tweet is taken down, you still have a Twitter account, do people care as much? I don't think they do. That's not that big of a deal. Okay, you took my thing down. Fine. Great. Then you get to say, okay, Twitter took my post down because it broke their terms. That's not a big deal. What is a big deal is, by the way, we took your tweet down. Your account's gone forever. Wait, but what? Same thing with YouTube. Same thing with YouTube. Your account's gone forever. What do you mean? So this is a big distinction. Maybe that needs to be focused on in this Section 230 thing, because Section 230 doesn't say anything about removing users and removing user access. It simply means removing the offending content. How is removing someone defamation? Well, lots of companies who remove people can defame them during the removal. As a minor example, one of my live streams was taken down by YouTube and a message popped up that said I violated YouTube's policies because my video was spam, scam, or something else. But what they sent me was that I had infringed on someone's copyright. So if they sent me that I infringed on someone's copyright, and then they told my audience that I was engaged in scam, like scamming behavior, then they've defamed me because I wasn't scamming anybody. I also hadn't infringed on anyone's copyright. That's a separate thing, but that's what happened there. So the removal wasn't defamatory, but their message about the removal was. I know, that's what I'm saying. That's an accompanying statement, not the removal itself. I didn't say a removal was defamatory. So I'm not sure where you're getting the question there. But it doesn't matter if the removal itself is defamatory. If it causes damage, there's all sorts of ways to damage someone from the removal. Again, my old Twitter account had 27,000 followers when it was removed. I still have not recovered those 27,000 followers. I'm 10,000 short. And it's been a long time. That definitely hurt my business model. That caused me a measurable amount of damage because I'm no longer able to distribute my show content to as many people. So I can make a tangible claim of damage from that removal. Twitter is completely insulated from me filing a lawsuit against them. So let's see. Okay, back to this. Immunity from certain types of suits. Or to regulations that make it more difficult for other companies to compete with the carrier, such as franchise licenses. By giving these companies special privileges, governments place them into a category distinct from other companies and closer to some functions like the Postal Service that the state has traditionally undertaken. Jackie Zone, no, I'm not boycotting Coke. I don't boycott anything. I don't care that Coke is super woke. I don't support that. I also didn't buy this, by the way. This is not my purchase, but I would still buy a Coke if I wanted a Coke. I don't do boycotts generally. If I like the product, I will buy the product and use the product. If I like a competing product better, I'll buy that. But if you're looking for... if I go through the idea of trying to boycott everybody I disagree with, there's nothing I can consume. So no. Carla Markswell, I'm not ignoring super chats at all, actually. I read every single one of them. Second, governments have limited a company's right to exclude when that company is a public accommodation. This concept, related to common carrier law, applies to companies that hold themselves out to the public but do not carry freight, passengers, or communications. It also applies regardless of the company's market power. Internet platforms, of course, have their own First Amendment interests, but regulations that might affect speech are valid if they would have been permissible at the time of the founding. The long history in this country and in England of restricting the exclusion right of common carriers and places of public accommodation, that's what I was talking about yesterday, may save similar regulations today from triggering heightened scrutiny, especially where a restriction would not prohibit the company from speaking or force the company to endorse the speech. There is a fair argument that some digital platforms are sufficiently akin to common carriers or places of accommodation to be regulated in this manner. Carla Maxwell, you might be new to the channel, so you may not know. Just so you know, I do all $20 super chats, $20 and higher, as soon as possible. All the other ones I get to when I get to them, typically later in the show. That's just how it goes. So I recognize that you may not be familiar with that, but I will eventually get to your super chat because I will read all of them. So that's been a policy for a long time here. So sorry if you're not familiar with that, but that's how we do it. I had to implement that rule because I was reading super chats for like 2 hours every night. And I had to reduce the overall number of them. Okay. Here we go. Let's see. Yeah, there's a fair argument that some digital platforms are sufficiently akin to common carriers or places of accommodation to be regulated in this manner. And Thomas here, this is important. Thomas is sending out signals. He's letting people know these are effective arguments. Make the argument. These are the avenues. Let's take this case. Let's find one that makes sense and let's go for it. Let's flesh this out. In many ways, digital platforms that hold themselves out to the public resemble traditional common carriers. Though digital instead of physical, they are at bottom communication networks, emphasis on being bottoms, and they carry information from one user to another. A traditional telephone company laid physical wires to create a network connecting people. Digital platforms lay information infrastructure that can be controlled in much the same way. And unlike newspapers, digital platforms hold themselves out as organizations that focus on distributing the speech of the broader public. Federal law dictates that companies cannot be treated as the publisher or speaker of information that they merely distribute. The analogy to common carriers is even clearer for digital platforms that have dominant market share. Similar to utilities, today's dominant digital platforms derive much of their value from network size. The internet, of course, is a network, but these digital platforms are networks within that network. The Facebook suite of apps is valuable largely because 3 billion people use it. Google search at 90% of the market share is valuable relative to other search engines because more people use it, creating data that Google's algorithm uses to refine and improve search results. These network effects entrench these companies ordinarily. The astronomical profit margins of these platforms last year, Google brought in $182.5 billion total, $40.3 billion in net income, would induce new entrants into the market. That these companies have no comparable competitors highlights that the industries may have substantial barriers to entry. He's being a little coy on this one, isn't he? To be sure, much activity on the internet derives value from network effects, but dominant digital platforms are different. Unlike decentralized digital spheres, such as the email protocol, control of these networks is highly concentrated. Although both companies are public, one person controls Facebook, Mark Zuckerberg, and just two control Google, Larry Page and Sergey Brin. No small group of people controls email. Much like with a communications utility, this concentration gives some digital platforms enormous control over speech. When a user does not already know exactly where to find something on the internet, and users rarely do, Google is the gatekeeper between that user and the speech of others 90% of the time. It can suppress content by de-indexing or downlisting a search result, or by steering users away from certain content by manually altering autocomplete results. Grind, Schemler, McMillan, and West, How Google Interferes with Its Search Algorithms and Changes Your Results, from the Wall Street Journal, 2019. Facebook and Twitter can greatly narrow a person's information flow through similar means, and as a distributor of the clear majority of ebooks and about half of all physical books, Amazon can impose cataclysmic consequences on authors by, among other things, blocking a listing. As of 2018, Amazon had 42% of the physical book market and 89% of the ebook market. It changes nothing that these platforms are not the sole means for distributing speech or information. Whoa. That's a big line. It changes nothing that these platforms are not the sole means for distributing speech and information. Damn. A person always could choose to avoid the toll bridge or train and instead swim the Charles River or hike the Oregon Trail. But in assessing whether a company exercises substantial market power, what matters is whether the alternatives are comparable. For many of today's digital platforms, nothing is. If the analogy between common carriers and digital platforms is correct, then an answer may arise for dissatisfied platform users who would appreciate not being blocked. Laws that restrict the platform's right to exclude. When a platform's unilateral control is reduced, a government official's account begins to better resemble a government-controlled space. Common carrier regulations, although they directly restrain private companies, thus may have an indirect effect of subjecting governmental officials to suits that would not otherwise be cognizable under our first public forum jurisprudence. This analysis may help explain the Second Circuit's intuition that part of Mr. Trump's Twitter account was a public forum, but that intuition has problems. First, if market power is a predicate for common carriers, such as some scholars suggest, nothing in the record evaluates Twitter's market power. Second, and more problematic, neither the Second Circuit nor respondents have identified any regulation that restricts Twitter from removing an account that would otherwise be a government-controlled space. Even if digital platforms are not close enough to common carriers, legislatures might still be able to treat digital platforms like places of public accommodation. Hey, again, I'm glad Thomas and I are thinking the same way here. Although definitions between jurisdictions vary, a company ordinarily is a place of public accommodation if it provides lodging, food, entertainment, or other services to the public in general. Twitter and other digital platforms bear resemblance to that definition. This too may explain the Second Circuit's intuition. Courts are split, however, about whether federal accommodation laws apply to anything other than physical locations. Once again, a doctrine such as public accommodation that reduces the power of a platform to unilaterally remove a government account might strengthen the argument that an account is truly government controlled and creates a public forum. But no party has identified any public accommodation restriction that applies here. The similarities between some digital platforms and common carriers or places of public accommodation may give legislators strong arguments for similarly regulating digital platforms. It stands to reason that if Congress may demand that telephone companies operate as common carriers, it can ask the same of digital platforms. That is especially true because the space constraints on digital platforms are practically non-existent, unlike on cable companies. So a regulation restricting a digital platform's right to exclude might not appreciably impede the platform from speaking. It doesn't in any way prevent Twitter from speaking to not be able to remove someone. It in no way. This is one of the most frustrating, oft-repeated, and simply incorrect arguments that exist. That by Twitter being prevented from removing a speaker is somehow forced to endorse speech. They don't. They don't. noting restrictions on 1/3 of a cable company's channels, but recognizing that regulation may still be justified. Yet Congress does not appear to have passed these kinds of regulations. To the contrary, it has given digital platforms immunity from certain types of suits with respect to content they distribute, but it has not imposed corresponding responsibilities like non-discrimination that would matter here. None of this analysis means, however, that the First Amendment is irrelevant until a legislature, this is great, until a legislature imposes common carrier or public accommodation restrictions. Only that the principal means for regulating digital platforms is through those methods. Some speech doctrines might still apply in limited circumstances, as this court has recognized in the past. For example, although a private entity is not normally constrained by the First Amendment, it is if the government coerces or induces it to take action the government itself would not be permitted to do, such as censor expression of a lawful viewpoint. Consider government threats. People do not lightly disregard public officers' thinly veiled threats to institute criminal proceedings against them if they do not come around. The government cannot accomplish through threats of adverse government action what the Constitution prohibits it from doing directly. Under this doctrine, plaintiffs might have colorable claims against a digital platform if it took adverse action against them in response to government threats. But no threat is alleged here. What threats would cause a private choice by a digital platform to be deemed that of the state remains unclear, and no party has sued Twitter. The question facing the courts, that's because parties are remiss to sue Twitter because of 230 immunity. The question facing the courts below involved only whether a government actor violated the First Amendment by blocking another Twitter user. That issue turns at least to some degree on ownership and the right to exclude. Second Circuit feared that then President Trump cut off speech by using the features that Twitter made available to him. But if the aim is to ensure that speech is not smothered, then the more glaring concern must perforce be the dominant digital platforms themselves. As Twitter made clear, the right to cut off speech lies most powerfully in the hands of private digital platforms. The extent to which that power matters for purposes of the First Amendment and the extent to which that power could lawfully be modified raise interesting and important questions. This petition, unfortunately, affords us no opportunity to confront them. So, that is from Justice Thomas. That is the end of the opinion there. That's a good, well-reasoned opinion. It has some indicators as to what avenues people might pursue in regulating or having the courts recognize more appropriately restrictions on some of these companies. And there may be existing laws that would apply to them if they were recognized in a certain way. If they're recognized as a common carrier, then common carrier restrictions may apply to them. If they're recognized as having control over government space, he's basically indicating here that maybe some people should have sued Twitter rather than just Trump, and said that Twitter, that's the trick going on here at the end. No one sued Twitter for Trump's ability to block them. But is Twitter then capable? Let's take a look at this real quick again. Okay. So what he's talking about here is the idea that you might have missed this. For example, although private entity is not ordinarily constrained by the First Amendment, it is if the government coerces or induces it to take the action the government itself would not be permitted to do, such as censure expression of a lawful viewpoint. They sued Trump, right? And they said that Trump was the problem because he blocked the journalist, right? You're with me here. Trump asked Twitter to do the blocking. Trump can't actually block anybody. Twitter builds a function into their software by which Trump can make a request and block the account. In theory, Twitter has the ability to refuse Trump's block request. Right? Like, if Twitter just decided to write some code in and said New York Times verified journos can always access Trump's account and he can't block them. They can do that. We know they can do that because their moderators can't be blocked. Their content reviewers can't be blocked. So Trump, like Thomas just lays it out here. Trump asked Twitter to do something that was unconstitutional, and Twitter agreed, and Twitter did it. The problem with the case was that no one sued Twitter as a quasi-government actor. So now, somebody needs to sue Twitter or Facebook because a government actor initiating a block has now asked the platform to do something that the government can't do. Thomas lays it out right here. That's a phenomenal section of this opinion. There's more to the argument than that. There'd be a lot of case law and all that stuff, but this is really, really, this is an amazing 2 paragraphs that Thomas has here. So there you go. That's that. Very, very interesting stuff. I'm probably going to do a short video on that point because that's frankly, like, as I hadn't read this until just now, but that's what Thomas is saying right here. And it's not as obvious when you just read through it, but that's the underlying writing of that section. Angron, the angriest boy, what stops them from just leaving and moving to a friendlier country while not operating in the US? Well, if Facebook or Twitter were located in Canada, they would have already been sued out of existence. Really, pretty much everybody, every other country than the United States, because the Communications Decency Act only exists here. So, all of the defamatory speech that happens on these platforms, and a lot of it does, by the way, tons of defamation by other countries' standards happens on Twitter and Facebook. If they were in those other countries, they would have been sued to oblivion because they wouldn't have that immunity. Gerard Garvin says, Nick, every time you take a sip of Coke, you're kicking America in the balls. No, I'm not actually. Like, Coke has a bad opinion. They do. But they have a right to have that bad opinion. They do. All of them have that opinion, though. They all do. So, sorry, I have to drink something. I'm not at my house, so I don't know what to tell you. Thirsty. All right. So that's this section. Next, I guess we have to do some guy in my comments is a moron. I guess that's next. I don't think I missed any. Hold on. Okay. I see Carla Maxwell's question here, and since we're in the middle of something and I see it, Carla asked, has it come out that they worked together at a bar and there was a history of confrontations? There is something. Something has come out regarding them working together, although I don't know that that's been introduced in court yet. I don't know that we have any information that suggests that them working together had anything to do with the act. That there's nothing specific about that I've seen so far in the case, but I haven't followed every bit of it. I've been on vacation. So that being said, remember that that's basically one person who said that they worked together and they weren't sure how well they actually knew each other. So, and that information came out a long time ago in the press, but as far as that information's impact in court, we haven't seen. Have you tried Zevia? It's amazing. What's your feeling with Coke Clear? I've never had it. I did notice we passed 1,000 likes. I have poured another shot of this terrible Florida whiskey. No one nowhere says the manager got her black guys mixed up. Oh, God. Okay. Let me bring up this YouTube comment thread. This is in regards to Kyle Rittenhouse and my own personal autism. Can I go? I don't want the... I shouldn't even be responding to this, but we're going to do it anyway. Okay, I did this Kyle Rittenhouse video a long time ago. So here we are. This is Kyle Rittenhouse, not guilty of unlawful possession of a firearm, because he's not. Look at the inception going on here. Oh, look. I can't wait to get back to my bookshelf. Oh, man. Oh, man. But anyway, this is a great video. Everybody should watch it. I go through and explain very clearly how Kyle Rittenhouse is not actually guilty of possession of a dangerous weapon by a person of under 18. He's not. He's not guilty under the law. He's not guilty. So, everyone should do this. Now, this video was like 4 weeks ago. In it, we have some comments going on. Just fine. They're going great. Ken A says, Nick, why are you drinking bad booze? Life is too short for the crap, dude. When I travel somewhere, I like to buy a local whiskey and try it. The last one I bought in Florida, which I think was called Wild Buck or something, was really good. Oh yeah, let me see if I can get dark mode for you guys, because it is really bright, isn't it? Dark theme. Oh, there we go. There we go. Much better. So I bought a new Florida whiskey this time to try out. And this one was clearly made with Florida man in mind, because it is garbage. Okay. So everything's going fine. Weeks ago, people are having this nice discussion, going through, and then someone mentioned, oh, this guy, Bork Baknam, you can't claim self-defense when you're actively looking for a fight. So I say you actually can claim self-defense even after you start a fight if you reasonably are in fear of your life and if you've exhausted all other avenues to escape. You're not condemned to die because you start a fight. This is going to become a recurring theme in this video, okay? In this discussion. This is something that so many people cannot seem to get their heads around with the Kyle Rittenhouse case and with other self-defense cases. You are not condemned to die by another person's hand because you did something silly, because you did something stupid, or because you did something even illegal. Okay? Like you get in a fight with someone and then they pull a knife on you. You're like, well, I got in a fight with them. I guess I'll just get stabbed and die now, is not how life goes. You don't actually have that requirement to die because you did something wrong. It doesn't work that way. So people are trying to do this with like, well, Kyle Rittenhouse broke curfew. So what? Oh, well, I guess he was out past curfew along with all the other people. I guess since he was out past curfew, he should just die then, right? If someone wants to kill him, they should just be able to kill him then? What's the solution here? None of this changes the calculus on whether or not he committed a justifiable use of deadly force. That's the question. Was he in reasonable fear of serious bodily harm or death? That's it. If the answer is yes, then we look at a few other limiting factors and say, justified or not. That's it. Phoenix Orem says, hey, Nick, can you bring Mike Boudet on your show? I have before, and I would love to do it again. I love Mike. He's awesome. Someone is trying to cancel him off his platform over his opinion on a murder. You love/live for this kind of drama. There's a YouTube vid. Hope you're enjoying Florida. Godspeed. Yep. I dropped Mike a line the other day. I'm limited on guest appearances on the way on this while I'm here in Florida, but I go home tomorrow. So I'll be following up for more guests coming up. Speaking of guests, I need to get on the show again. Robert Barnes there in the chat. Hey, what's up, Robert? How's it going? Robert Barnes says the gimme 3 steps rule from Leonard Skinner. No 3 steps, right of self-defense. Yeah, it's there you go. There you go. And Robert Barnes, of course, is tangentially associated with Kyle Rittenhouse and with, I believe, managing funds or something like that for his defense. And he deserves a little bit of props for that because Kyle needs all the competent help he can get. Robert's a very competent and very cool guy. So, okay, so we're going through. Then this is all a waste. This is all weeks ago. Everything's going just fine. People are just having their conversations. Then 6 days ago, we go from 3 weeks ago to 1 week ago to 6 days ago, and then things start to get interesting. Here's where it starts. Here's where it starts. 5 days ago. Yes, I've been dealing with this for 5 days. Simon says, what is the definition of the words negligence and culpable, and why don't you think they apply to Kyle? Well, here's the deal. Kyle isn't charged with culpable negligence. That's the biggest, number one reason that negligence and culpable's definitions don't apply to Kyle. They have not charged Kyle Rittenhouse with culpable negligence. They have charged him with reckless behavior and intentional behavior. That's it. There isn't anything else in the charging document. It's all reckless discharge of a firearm, and intentional murder. That's it. So that's the first thing. So this guy's doing yeoman's work. So they don't apply when 3 adult felons attacked a child. Try again, nerd. Nailed it. Perfect. Says who? You? Well, culpable negligence actually just doesn't apply to Kyle at all because he's not charged with it. He's not charged with it at all. I can't get a... Ask any responsible cop if arming yourself and then disobeying a governmental curfew to put yourself in harm's way is negligent, and they will say yes. That's not negligent. There's not that. Culpable negligence tends to involve a criminal charge, and Kyle is not charged. You know what Kyle's not even charged with, by the way? Kyle's not charged with violating curfew. Shocking. And by the way, any responsible cop, if arming yourself and then disobeying a governmental curfew to put yourself in harm's way is negligent, and they will say yes. Actually, you can probably ask responsible cops and they will say no all the time because they have nothing to do with that. Oh, hey, Snake Dude for Life. He's there in the chat. What's up, buddy? There you go. Sorry, try again. Gun cultist. Says the law's on Kyle's side. Bootlicker. Good job. Define negligent and culpable. Gun cultist. Liking your own comments is gay. Here. I'll like his comment. There, he's not the only one. He says, make me define it, bootlicker. You'll learn it when Kyle walks. Stay mad, nerd. Okay, so here we go. This keeps going until, I should say, this guy was in another comment thread. I don't know where it is because of how YouTube manages notifications. So he brought up the negligence thing. I talked about this the other day. I thought it was all in the same thread. Sorry. Let me briefly summarize that conversation for you. Simon says, define negligence. Or no, he said, can you define negligence? Wait, how did it start? That was the third comment. The first one says, he said, is Kyle negligent for arming himself and going out into whatever? And I said, no. And he said, can you define negligence? Under was yes. But that's all I said. So then he said, go ahead and do it. And I said, no. And he said, why not? You must not know what negligence is. I said, no, there's just no value in me writing out a law review article in YouTube comments. There's no purpose to doing it. And negligence doesn't apply to Kyle's case because he's not charged with culpable negligence. There's no criminal negligence charge. There's no reason for me to write out what negligence is under Wisconsin law because he's not charged with it. So if they're not going to charge him with it, obviously the prosecutors don't think it's a viable theory because it isn't. Okay. So that being said, that's how that conversation went. And then he's like, lol, you must not know if you won't bow to my demand for you to write a law review article about negligence. It's like, okay, well, you can't get past that. So then he tags me here and he says, looks like Kyle could have kept running in between the cars rather than stop and shoot Rosenbaum. It's Rosenbaum, but he says Rosenbaum. So that's why I start this with, oh God, you again. It's because of the other chat thread. All right. Here's where this starts over the past day of what I've been dealing with. This guy supremely annoyed me. He said, there's no duty to retreat in Wisconsin. There's no duty to retreat. If you are in reasonable fear of serious bodily harm or death. Now, serious bodily harm tends to involve some sort of, I guess the easiest way is to think of some sort of major injury, a severe laceration, a broken limb, a concussion, something like that. Something that could involve hospitalization or stitches or permanent scarring. Those are serious bodily harms typically. Each state is going to have a little bit of a variation on that. So you can't take that as like specific advice for every state, but more than just a minor bruise, right? More than being slapped or a scuff or a scrape. We're talking about a serious injury, serious bodily harm. Something you would want to go to the hospital for is a good barometer for serious bodily harm. So obviously any head injury is serious bodily harm, any broken limb, serious bodily harm, and then severe lacerations requiring stitches are a very good one. Blunt force trauma to soft tissue, that's going to require you to be hospitalized. Like if you got bleeding kidneys, there's no broken bone, there's no laceration, but if someone's hitting you hard enough in the kidneys that you're going to be pissing blood, that's serious bodily harm. All right. So that's kind of the barometer there. If you're in fear of serious bodily harm, reasonable fear, or death, you are justified to use deadly force in Wisconsin. You do not have to walk away. You don't have to run away. You don't have to lay down, sit down, stand up. You don't have to close the door. You don't have to close the window. You can shoot the person in the face at that point. That's how the law is written. Obviously, practically, things don't go that smoothly. And if you're ever taking someone's life, you should expect a lot of legal consequences. But, those legal consequences are something you fight because you stayed alive. And that's preferable. All right? So that's kind of the basic gist. There is a time where you may incur a duty to retreat in Wisconsin. And we'll address this with Kyle's case as well. And that is if you instigate a conflict, you start a fight with someone, you cannot then use deadly force unless you have retreated. So even if you're in reasonable fear, if I start a fight with you, like we start slapping each other, calling each other, betas or whatever, and we're like, we start slapping, and then I get into reasonable fear, I can't suddenly pull out a gun and shoot you. I have a duty to retreat at that point. But once your escape option is gone, your duty to retreat ends. If your back is to a wall, literally or metaphorically, your duty to retreat ends. Okay? So we have to apply this possibility to Kyle Rittenhouse's case because part of the prosecution's theory is very, very probably going to include the idea that Kyle Rittenhouse caused the conflict with Rosenbaum. That he is responsible. Whether they can prove that or not, I don't think that it's reasonable under what I've seen, but they're going to make the argument that Kyle Rittenhouse caused the conflict with Rosenbaum, and therefore that negated his automatic simple right of self-defense, and he had a duty to retreat. The problem, of course, with that argument is that Kyle Rittenhouse did retreat from Rosenbaum. He did. He retreated until Rosenbaum caught up to him, and then he fired at very close range and fired the fatal shots. And also there was a gunshot that preceded Kyle Rittenhouse's gunshots, and that probably put him in extra fear. And it does not matter that the gunshot was not fired by Rosenbaum because Kyle may not have known that. So anyway, these are some of the arguments that are going to be over the facts. So there's no duty to retreat in Wisconsin. He didn't have to take a single step. That he chose to initially retreat is to his credit, but as Rosenbaum gets closer, Kyle's justified if he's in reasonable fear. This is always the question. Is his fear reasonable? Rosenbaum was yelling at Kyle. He was making aggressive movements and eventually chasing him and throwing stuff at him. Is he reasonably in fear? I say yes. Jury will have to determine that. It's clearly established by video that during a chase, a different person discharges a gun nearby. That combined with Rosenbaum's hostility and closing pursuit can easily establish reasonable fear for Kyle. Even absent the gunshot, Kyle can justify the shoot based on Rosenbaum's unreasonable and unjustified pursuit of Kyle. This is a pretty clear case of justifiable deadly force. Notice I'm nice. Notice I'm nice here. Simon Says responds, I was just saying he had a way out through the cars. Doesn't matter. Is it reasonable to assume one would get attacked at a riot? What do you guys think? Before I say anything about this, here I'll scroll up so we don't have no spoilers. What do you guys think? Is it reasonable to assume one would get attacked at a riot? Is that reasonable? Yes or no? If so, why would you go when the government tells you there is a curfew? Isn't that negligent behavior? The answer to this, no matter what the answer to the first one is, no, by the way. So we've got some yeses, we've got some nos. I say no. I say it's not reasonable to be assumed you'd be attacked at a riot. I say no. Because I think what you guys all did is you guys put yourself in the mind of someone confronting the riot, because that's who you are, right? You guys don't approve of rioting, so you put yourself in the shoes of someone who is countering the riot or something like that. This is a fine opinion to have, by the way. It's a fine opinion for you to have that it's yes. It's also the smart opinion to have for a normal person to say, I'm going to stay away from riots because I don't want to get stabbed. My personal opinion, I don't even go to peaceful gatherings in large numbers because I don't want to get stabbed. I don't want things to go wrong. Okay. So if you're a Chauvin, you go to a BLM riot, then you should expect to be attacked. Yeah, certain specific circumstances, okay? So here we go. Simon says, I would go away if you just define negligence and give 3 examples, please and thank you. No, here we go. Okay, so here's my response. Kyle is not charged with criminal negligence. His acts were willful, not negligence. He's charged with reckless and intentional acts, not negligent acts. I don't want you to go away, but I'm also not going to write a legal summary of negligence for you when it has no relevance to the case. You're not understanding negligence is your problem and no one else. Okay, just because Kyle isn't charged with negligence doesn't mean his actions weren't inherently reckless and negligent. Reckless is different than negligent. Those are two, you're using legal words, but you're not using legal definitions. That's the problem. Can violating a public safety restriction, such as a seatbelt or curfew law, make a citizen culpable for any loss of life their decisions and actions help perpetuate? Not in self-defense situations, no. And again, if it's culpable negligence, Kyle would be charged with culpable negligence. He's not. Said, you must not realize somehow that breaking curfew isn't a death sentence. This is this guy's thing, right? He broke curfew and went to a thing. So we're going to get, I think I respond to the whatchamacallit. I think I respond to the reasonable to assume attacked at a riot coming up. I forget the order of these. So Simon says, if 2 people get in a fight in public during a riot after a government calls curfew, couldn't they both be charged with simple affray no matter who attacked first? Maybe. Maybe they could be. I don't know about the mutual combat laws in Wisconsin. I don't know if there would be it seems weird to charge 2 people involved in a simple fight at a riot with disorderly conduct when everyone around them is engaged with disorderly conduct, but possibly, I guess. And doesn't this set a precedent? No. That if 2 citizens are in a place and time the government forbids them to be and have conflict, they must share the culpability of their actions regardless of who chased who? No. 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 Here's part of the problem with his whole reasoning. Kyle Rittenhouse didn't attend a riot. Kyle Rittenhouse was standing with permission on private property. So that's part of the problem, but we haven't even gotten there yet. Oh, sorry. I don't realize how loud that is. That's my bad. Okay. Next. And breaking a curfew isn't a death sentence, but neither is 25 to life in prison. Ha ha ha. Breaking a curfew isn't a death sentence because you're not condemned to die because you didn't obey a curfew order. And neither did the other parties. So at worst case, Kyle is on equal footing with the people he ended up killing. So that negates any sort of disparity that might have existed in their legal positioning. Rosenbaum and Kyle, at worst case, are both violating a curfew order. However, Kyle was on private property, and I believe he had permission to be there, or at least believed he had permission to be there. These are important things that won't matter anyway. On civil law, I haven't read their API decision. I haven't read it. I heard about it, but I have no idea what's going on. I'll have to take a look at it. But I love your musical citation there. Okay, so then I respond. But two people didn't get into a fight in public. And even if they did, and one person reasonably fears for his life, he is allowed to defend himself. You're prodding into areas that are irrelevant to the case because you're inventing facts since reality is inconvenient for you. I'm sorry that you don't like Wisconsin law, but Kyle even meets the higher standard of retreating that could theoretically be required if they determined he was culpable for an initial fight. There's no evidence to support this, however. Even if there were, he did retreat. That is absurdly important to this. Even under the heightened standard for justifiable use of deadly force, Kyle Rittenhouse retreated. Now, again, I'm sorry I have to expose you to this, but if I'm in pain from dumb comments, I want to make sure that you are in pain with me, because I have a reverse sort of empathy. I want to force pain upon you if it happened to me, because I don't want to deal with it alone. I agree that Kyle did retreat. However, he was acting unlawfully the moment he agreed to go to the riot against the caution of the authority and the governing body. First of all, he's not charged with this. Second of all, it doesn't matter to the calculus of self-defense. He went with the intent to be part of an armed mob. This is assuming facts, not an evidence, by the way, that potentially would have to face off potentially against a not quite as armed mob. How would he go into this with that intent? He has no, this guy is just literally made up intent and facts about both mobs. We do know that the other mob had guns as well. In fact, someone fired one randomly. Gage Grosskreutz had a gun and tried to shoot Kyle. The property Kyle went to guard was already burnt down. Actually, this is not true, I believe. And even if it were, that's my heap of rubble, and I will defend it if I want to, or I will ask people to defend it. The property owner did not ask Kyle to be there. He may have asked various people to be there. I believe there was some sort of permission given to somebody. Though he may not have asked Kyle directly, he may have given permission to other people. This fact is not currently in evidence. We'll have to figure that out. Kyle left the property and the company of his friends after he acted as an armed guard with no legal authority to do so. You don't have to have legal authority to carry a rifle in Wisconsin. You have it. It's in the law. It's in the law, which is something a reasonable person wouldn't do. Well, first of all, again, this is the problem with trying to argue legal stuff, right? He's using legal words here. He's establishing a reasonable person standard for something that doesn't exist. He's saying no legal authority when you have legal authority to open carry in Wisconsin. You can carry a rifle. You can do it. NW Backcountry, you being on vacation kind of sucks for chat. Why is that? What's going on, buddy? But anyway, I go back home tomorrow, so don't worry about it. Okay. His acquaintances, Blatch, not Black, was at the gas station Kyle was seen at moments before. This is completely irrelevant. That doesn't matter at all. Very weird. Why would a kid with a gun willingly seek out solitude during a dangerous riot when he was threatened? Kyle wasn't alone. Kyle wasn't alone at all during this. I don't know where that comes from. Kyle was standing next to someone else when Rosenbaum started chasing him. This is weird. You're quick to accuse me of disregarding and ignoring the law, but Kyle disobeying the curfew law. And this is where this dummy is hanging his hat, right? Like, this is the whole thing. He thinks this is the big gotcha. There's a government curfew. He's out. Therefore, he has to die. To be a do-gooder whilst armed with a deadly and dangerous weapon. Okay. To look for wrongs to right. I don't think he was looking for wrongs to right. This is, again, assuming something that doesn't exist. And property to save. I don't think he was looking for property to save. He knew where he was going. Uncivil Law says, want to have a shot drinking contest? I no longer want to feel. Bring your A game, you pansy. Let's go. Tonight, Uncivil? I'm already... This is like my third glass of whiskey already. Is there... Did I lick a furry or something? Do I have AIDS? While threatening potential lethal force with no governmental authority, he didn't threaten potential. This is a weird thing. You can't threaten potential force. You can't threaten a potentiality. Like, a threat is a threat or it's not a threat. Look, you guys have me keep drinking liquor. I'm going to have to go get another Coke. I'll spot you 3 glasses. Let's go. How do we keep track of this, Uncivil? I feel like there's one side that has evidence and the other side that doesn't. Uncivil, you want to do it tomorrow night? Can we put this off till tomorrow night, Uncivil, when I get home? Because I have to wake up early tomorrow. But tomorrow night, I'll have you on the show and we'll just get trashed. How's that? Let me know. With no governmental authority, the government does not have a monopoly on force, by the way. Is the kind of behavior a reasonable person would expect to cause a shootout in the street, correct? No. No. This is not the kind of behavior a reasonable person would expect to cause a shootout in the street. All right, Uncivil Law and I drinking contest tomorrow. One of us will probably leave dead, and it'll probably be me. Sounds good. Sounds good. I'm looking forward to it. That'll be great. So come back tomorrow for that. You are weak. I will take you. You can't even spell weak. I am 7 days. You will take me. Well, okay, fine. Challenge accepted. I will be 7 days and you will take all 7 days to drink. That sounds like the weak one. Oh my goodness. All right. So we go back to this. We will go back to this. No, not correct. It's not correct. So his question is this correct? No, it's not correct. Curfew orders don't even mitigate justified use of deadly force. Not at all. You can check the justified use of deadly force statute. Curfew is not one of the mitigating factors. He was legally carrying a legal firearm. He had permission to be on the property where he first made the first shot. Now, this is from what I've heard. I guess I could be wrong about this. And even if he didn't, that still would not mitigate his use of deadly force. Shockingly, by the way, if you are running from someone and you end up trespassing onto private property because they're trying to kill you and you shoot them, they don't say, well, you trespassed. Now you die. Now you have to die. Sorry, you can't self-defend because you ran onto someone else's property while you were running away. Sorry, you have to die now. That's not how this works. I don't know if anybody understands this. I mean, I know you guys do. I don't know if dumb people understand this. Just because you break some law, or typically some civil offense, and outside of a no trespassing sign, by the way, he's not guilty of criminal trespass unless someone tells him to leave. And he refuses to leave. Unless there's a clearly marked sign that says no trespassing, which I'm not aware of, considering it's a business. Commercial properties tend to not have no trespassing signs when they're a business property that's not like a junkyard or something like that. So even if he didn't have explicit permission to be on that property, he's not criminally trespassing. He may have been civilly trespassing, potentially, if he caused damage to the owner in his civil trespass. That's not a question here. Not atheists. I will read your super chat. I will read it in a minute. So, okay. So him being at a riot is irrelevant. He wasn't engaged in rioting. And even if he was, repeat ad nauseum, it still would not mitigate his use of deadly force. The only thing, by the way, if you attend a riot, which I do not recommend, but if you attend a riot and someone tries to kill you and you have to shoot them, even if you were engaged in rioting, and you become in reasonable fear for life or serious bodily harm, you still have your right of self-defense. This is a dumb argument. Cloudfire 181 says, hey, Nick, today I'm free of student loans forever. I'm at a milestone that most people wish they could. Hope you're doing well. I am doing great, and that is awesome, buddy. Cheers to you. Cheers to you. I will pour out some bad Florida whiskey in your honor. Don't go to law school. You'll get more of them. An unreasonable amount. Okay. The only thing that mitigates his use of deadly force would be a purposeful attempt to incite violence against himself with a premeditated purpose to use self-defense. This is what we were talking about earlier. There's not only no evidence of this, there's a ton of evidence against this, and you acknowledge one of the biggest ones. He retreated. You can not like the law, but that is the law. Here we go. That wasn't the question. Did Kyle engage in activities or behavior that a reasonable person would think could have a high likelihood of causing a shootout? Yes or no? No. 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 You carrying a gun has nothing to do with a shootout occurring. Lots of people carry guns and no shootouts occur. Millions and millions of people every day carry guns, and the number of shootouts that occur is zero on the average day. Like, shootouts are a rare thing. That's where shots are exchanged. This wasn't a shootout, by the way. This was a shoot in to the bodies of pedophiles like Joseph Rosenbaum. Like, this is a shoot in. This is not a shootout. He put bullets in people, not out at people. So anyway, no. A reasonable person would think could have a high likelihood of causing a shootout. I'm going to go and stand on a property and I'm going to arm myself with a rifle. And does that reasonably mean I'm going to get into a shootout? No. Lots of people carry a rifle and don't get in a shootout. Again, I don't know how else to say this. And my point on this is the riot and the getting attacked or whatever. The overwhelming majority of people at riots do not get attacked. Do not. So when you guys, when I said no, like, should a reasonable person expect to be attacked at a riot? No. A reasonable person should not expect to be attacked at a riot. Because the overwhelming majority of people at a riot don't get attacked. They don't. It's a weird thing, but it's a fact. Because if they did, by the way, there would be way more injuries and deaths if the majority of people got attacked at riots. Riots happen all the time, and an overwhelming majority of people do not get attacked. Property gets destroyed a lot of times. Police might get, might clash with people. But if you go attend a riot right now, chances are you're not going to get attacked. Now, if you go counter protest or something, it raises the chances a little bit, but it's really a little bit. Most protests and counter protests, most people at those things don't engage in armed or unarmed conflict. A subset of people will typically be engaged in that. All right. So anyway, I forgot to mention no, and that question is legally irrelevant. Of course, this is the main thing here. All of this is legally irrelevant. So criminals that aren't going to listen to cops and the government are suddenly going to stop committing crimes because some kid with a gun and no authority shows up to a city at a time of general lawlessness and engages in base level lawless behavior and demands they stop setting dumpster fires. One, I don't know that Kyle Rittenhouse was planning to single-handedly, like Superman, stop what was going on in Kenosha. So we've taken these goalposts, by the way, from this weirdo. We have picked them up and converted those goalposts into a different sport. Like they're now a hockey net and then a bunch of lingerie for fat women. I don't know like what has happened to the goalposts that we were at, but now we've gone from Kyle was part of an armed mob to stop a less armed mob to Kyle alone showing up with a gun was to stop people from lighting dumpsters on fire. I don't think that was, you know what? I have a weird idea that Kyle's thought process when he goes, I'm going to go to Kenosha with my friend because he asked me to come help him watch over this property. I don't think that Kyle said, I'm going to go to Kenosha. I'm going to single-handedly stop dumpsters from being lit on fire. That's what I'm going to do today. So we have moved all over the place. I don't know where the hell this guy's argument even is. Criminals aren't going to listen to the cops, but they will listen to curfew violating teen vigilantes with guns. Who said Kyle Rittenhouse thought anybody would listen to him? Again, these are weird assumptions to make. They're not in evidence. They're not at issue in the case. I don't know why this guy wants to have this masturbatory conversation, but he does. So again, so you have to suffer. No, they wouldn't. I don't know if even Kyle would disagree with this. It's just not relevant. Going armed to a riot and expecting the best possible outcome is ignorant, at least, and criminally and recklessly naive. First of all, going armed to a riot and expecting the best possible outcome is the outcome for the overwhelming majority of people who go armed to a riot. This is, again, the absolute dumbest point that this person keeps making. 99.99% of people who attend a riot armed get the best possible outcome. They don't even go to jail. Because remember, most of the armed people attending a riot are rioters. They don't even end up going to jail most of the time. Joseph Kerwin says, was it negligent of Rittenhouse to not wash his miniatures with warm soapy water before? You motherfucker. I did wash the minis with warm soapy water. It's the type of plastic that Todd McFarlane uses. I washed them. It's primed twice. Oh, God, you're pissing me off. If it's reasonable to assume you would be attacked at a riot, it's not. Again, which Kyle must have been thinking as evident by the rifle he had with him. Nope. This is not... This. By the way, lots of people... Lots of people carry a gun every day, not assuming they will be attacked. They hope for the best. They assume the best. Most people carry a gun every day and will never have to draw it because they will never be attacked. The overwhelming majority of people are not attacked. But they carry a gun in case of the worst. Not assuming they'll be attacked, but in case they get attacked. Way different. Then why on earth would you disobey the government to be in that situation? Look at this fucking govcuck. Look at this govcuck. Why would you disobey the government? How could you not listen to the government? I mean, Jesus. Most people don't listen to the government in some way every single day. Imagine being this much of a bitch. It's not reasonable to assume you'll be attacked anywhere. The overwhelming majority of people at that riot were not physically assaulted. Your entire premise is ill-conceived. Oh, autocorrect. No, it never happened. No evidence. There's no evidence of my typo from autocorrect. Ill-conceived. 78 Swilly, yes, I have merch. I do. It's on Teespring. It's actually probably scrolling by below your video. You should check out My Rights Don't Care About Your Feelings shirt. It's great. It's great. All right, next. His response. Now we've triggered him into multiple responses for everything. But you are ignoring the glaring issue with your thought that it isn't reasonable to think you could be attacked at a riot. Could be and will be are different, by the way. But again, just because you could be something, look, I could be attacked in my home right now. I could be a bear could rip through this window and maul me to death. That could happen. It's a possibility. A Florida man high on flakka could run through the door of this house, stab me with meth needles, and then rape my corpse and cut off my face. It's a possibility. That can happen. That could happen. I have to consider that every time I come to Florida. That's a possibility. It's Florida, right? An alligator may try to eat me at any given moment. There could be an alligator in my toilet. I don't know. If Kyle didn't think it was reasonable to assume he would be attacked at a riot, then why did he have a gun when he left to go to the riot? Again, these are disconnected phrases. Uncivil Law with a huge chat says, love you, man. Notice me, senpai. I need your love and attention. Why don't you notice me? I am not obsessive. Why would you say that? I don't know. Balls or no balls? I demand to know. I am so drunk right now. Bring it, bitch. Uncivil Law, you should know this. The answer is always balls. Balls always. Balls is the way. All right. Kyle must have either thought he would be attacked for engaging in the activities he was planning on engaging in at the riot, so he brought the rifle to defend himself, or he planned to attack someone with it. Nope. This is what we call a false choice fallacy. This is a false choice fallacy. You don't have to think either of these to carry a rifle. In fact, you have the right to carry a rifle because maybe he thought there would be a deer in the street and wanted to shoot the deer. I don't know. It doesn't matter. In the United States, this is something that has gone so far beyond the absolute vaginal left. No, that's rude. That's rude to women. I know tons of women who are supportive of the Second Amendment, so that's rude. How do I say this? The absolute cuckery of the left, I guess, is the best way to do it. It's the best way to say it. The absolute cuckery of the left is that you somehow need a reason to exercise your Second Amendment right. You don't. You don't ever need a reason to carry a gun. The idea that you need a reason to have, to keep, to bear arms, the idea that you need a reason for it is anathema to the right. You have to have a reason to speak. You have to have a reason to have access to an attorney. You have to have a reason to not have your property taken by the government. You have to have a reason to not have soldiers in your house. You have to have a reason to be free from unreasonable search and seizure. You have to have a reason to not be tortured by your government. No, you don't have to have a reason. That's a right. Rights don't require reasons. Ever, ever, ever. Uncivil law. You're beyond kind of drunk right now. I think you're super drunk. It's great. He also said balls, noted lol. You don't have to have a reason to exercise your rights. By the way, they don't believe you need a reason to abort your baby. Right? In fact, asking if you got to an abortion clinic and the government said that the woman must provide a reason to abort her baby before the clinic can grant an abortion, that would be an unlawful infringement on their right to an abortion. It would be in violation of Roe v. Wade. They cannot do it. They can't do it. That would be an impermissible barrier to their right to an abortion. And the left would have a fit if a woman had to provide a reason. And has had a fit for states who have tried to require women to provide reasons. The reason we know they would have a fit is because they literally have had a fit. That's why the reasons for having an abortion, all of those surveys that have the reasons for the abortion are voluntarily obtained reasons because they can't force a woman to do it. And it's important to note, as Chambers of My Heart properly lays out, abortion is not, she says it's not a constitutional right. The Supreme Court disagrees, even though the Supreme Court is vastly incorrect on this. But let's clarify that and lay that out. It's not an enumerated constitutional right. It's not explicitly in the text. They've inferred a constitutional right through the 9th and 4th Amendments, and that's what they've done. And then applied it through the 14th Amendment, but that's a whole thing. That's a whole different debate. And maybe Uncivil Law and I, while we're super drunk tomorrow, can talk Roe versus Wade or something. But that being said, it is not an enumerated constitutional right. Your right to keep and bear arms is. Okay. This segment's going longer than I thought it would. Okay. And so then he goes back. So remember, Kyle must have either thought he would be attacked. This is a false choice fallacy, or both. That you can't negate a false choice fallacy by adding a third choice that is both choices. That doesn't negate a false choice fallacy. The point is that Kyle more than definitely thought the behavior he was going to be engaged in could cause him to shoot someone. Nope. That's not what happened. You have no evidence about that at all, which is exactly why he shouldn't have gone to a riot against the will of the government. Take this out, by the way. Take out against the will of the government, and I agree with you. Kyle should not have gone to the riot. And I think in hindsight, Kyle would say, man, if I could do it over, I probably just wouldn't go there because I'd rather not be going through this. I'd rather not have my life ruined by a bunch of fucking piles of garbage like Simon says. Right? Like, I think Kyle probably doesn't want to have stupid pieces of shit like Simon says trying to have him go to prison forever. And even if he doesn't go to prison, trying to ruin his life for as long as he lives. He's only 18 now. Now he's 18. And people like this will try to ruin him forever. Uncivil law, you better stop. I will call the police and tell them you are drinking to dangerous levels. I will red flag you right now. Right now on stream, I will red flag you. You better stop. Don't you trigger me. But I say to everybody, don't go to riots, don't go to protests, don't do any of that stuff. You're too old. I don't care if you're 4, you're too old. You're too old for what can happen to you. Don't do it. It's not the best move. We can fight in different ways. DH DeVillian says, hey, Rackets, a long while ago, you posted a GoFundMe for my friend who lost his driving job. Just wanted to say thank you to you and all the viewers that helped him out. He made it through and is doing well now. Oh, that's awesome, DH. Thank you. Okay, so anyway, going armed to a riot with the idea you will be a security guard or vigilante insurgent forces. Insurgent force? Again, this person is just putting words down that he's heard somewhere. Insurgencies are counter-government. Going and standing guard, even if that's what you're doing, going and standing guard during a riot is not insurgency, you moron. It's not even close to insurgency because the riot isn't government, the government. Even if we can make a tacit argument that it's government endorsed because they just didn't punish anybody during these riots, even if we can make that argument, it's not the government itself. And there's no aim to overthrow the government by standing at a used car lot with a gun. You fucking idiot. And recklessly negligent. Recklessly negligent. Those are two different things. There's recklessness and negligence. Those are separate. They don't. Reckless is not an adverb of negligence or an adjective. Teleco Friedman. Even if the riots are government, you're not overthrowing the government, so they're not insurgent by definition. Okay, so my response. 8 hours ago, we're down to now. Nope. In Wisconsin, you can open carry a rifle in public just because. It has nothing to do with anticipating being attacked or being a security guard. And even if he did, it doesn't change the justifiable use of deadly force question. Remember this? Remember this? This is important. The fact that you don't understand this at this point, this is where I've lost my cool. I'll take it. I'll take my licks, preferably on the penis. I will take my licks, but I've lost my cool. The fact that you don't understand this at this point is fucking embarrassing. Just go read the statute for justifiable force in Wisconsin. I realize this will spark endless, more retarded questions from you because you refuse to read what is written and decide to just make believe requirements that aren't in the law, but one can always dream that you'll be less of a dummy. Half-Eaten Hooker says, as a defense lawyer, would you argue a law is unfair during a trial or have to fight it outside a trial? For instance, a dealer blamed for an overdose. No, you would argue that in the trial. You would make that part of your case. You'd make a compelling legal argument in a brief to have it dismissed, and then you would appeal that decision to the appeals court and then to the Supreme Court of the state or government, or U.S. Supreme Court. That's how you would fight that. You would fight that in the case. You may similarly lobby your congressman. By the way, no congressman on earth is going to, especially during an election year, reduce criminal penalties for drug dealers. It's not going to happen. So no. But generally speaking, you would fight that in the case. You would say this law is unfair, unconstitutional, ridiculous. It implies, it applies in crime of intent, to someone who didn't intend something. There's an intervening cause. The intervening cause is uncontrolled by the person who is bearing the weight of the crime. You'd make these arguments. It's a tough argument. Congress may have the ability to regulate it. I disagree with the law. Congress is the better way to fight it. But if you have the case for the third degree murder charge for a drug dealer in Minnesota, like who happened to deal drugs to someone and they happened to eat all of the drugs at the same time rather than taking them at the normal dosing schedule or whatever, so they could just be a high waste of life, you'd make the argument in court. You'd make it in court documents and then you'd appeal it up, delay out the trial forever. Buy your client as much time as he can. Maybe he'll leave the country. That's a joke. Breck. I'm going to talk to you very seriously right now. You listen real careful. You're on thin ice with me. I know you're either a cop or a former cop. And I have some respect left for law enforcement. Don't you dare pilfer the last vestiges of respect I have for police by implying that cops are okay with cake donuts. You son of a bitch. Look, cops are experts in donuts. I know you're lying to trigger me. I know it. Don't you dare even consider ruining the last vestiges of respect that I have by saying something like that ever again. I won't have Angry Baneling ban you, but I will have Angry Baneling ask you to open Bob's and Vagine all day long, as is his nature. I will tell him you're a redhead waifu, and you will have nothing left. All your DMs will be ruined. Okay. Whew. I got a little triggered there. I've calmed down. The thin cake blue line. Tom Bullis says the last stream on your other channel is 5 days ago. That's because my other channel got a strike. It got a strike from YouTube because YouTube is a giant pile of ugly vaginas, and I hate their misapplication of policies. They said I advanced false information of COVID. I dispute that. I dispute that claim. And waiting to hear back from my YouTube partner. It is bullshit. But until that strike is gone, I can't upload over there. Breck says, lol, it was a yeast donut boiled and fried at a Korean place. I knew it. See, Breck knows. I know. This is how I know Breck is actually one of the good cops. You see what he did there? He, like cops have the ability to do, he lied to elicit a response from the accused, me. I'm the accused in this case. He lied to elicit a response from the accused. He got the response, but at the same time, even though he lied and pretended to be a disgusting degenerate, he knew Asian, raised, fried, donut. He got it. This is how I know he's a good cop. This is why you don't talk to cops. They're too smart. Okay, here we go. Simon says, back to this. This is going way too long, by the way. This section was supposed to take like 10 minutes. We've been doing this section for like 2 hours. Simon says, 1, when the local government calls curfew, God, imagine being this much of a bitch. Can you imagine it? The only place you can open carry is on residential property, not commercial or public property. This is so embarrassingly wrong. I don't even know what to do about this. I don't even know what to do about this. This is so wrong. 2, the issue was, is it reasonable to assume you'd be attacked at a riot? Kyle thought he may get attacked, which is why he brought the rifle. This part you've made up. This part you've made up. My question then becomes, and this is important. My question then becomes, well, what if your then is predicated on a wrong thus? If he thought there was a high probability his actions may get him attacked, why would he go to a riot against the will of the government with a rifle to begin with? Did he want to be attacked? Oh, you know what? Yeah, you're right. Simon says he's figured it out. You know what Kyle Rittenhouse wanted to do? He wanted to face down death. That's what he's like, you know what? What I really want to do is I want someone to try and murder me. I want to be chased by a pedophile and then a wife abuser who's illegally carrying a gun, and then some weird skateboard cuck. I want to be chased by these people. I want them to try and kill me. Then I want to shoot them. Then I want to go on trial and be hated by the public due to a slandering media for the rest of my life. That's what I want to do. That sounds great. Really? Yeah, he wanted to be attacked. Lots of people want to be attacked. If not, he should have stayed home. What? Oh, so if he goes, listen to the reasoning. Like, just reverse the logic in this dummy's brain for 2 seconds. If he didn't want to be attacked, he should have stayed home. I'm fucking sorry. What? What? If you don't want to be attacked, just stay home. That's anathema to freedom. That's anathema to your rights. Like, if you could effectively do this, the entire population of the earth could be controlled by 5 people in every city. You just say, well, look, one cartel with 5 people. Look, if you don't want to be attacked, you just stay home. It's fine. And then that'd be okay? No, fuck you. I'll go out and I'll piss in your damn mouth. Get out of the way of the urine stream, bitch. What are you doing? I'm just peeing here in public. Arms out, dick out for Harambe. I am urinating into the wind and your face gets in the way. That's your fault. Get out of the way. Right? That's the same thing. It doesn't work that way. Look, if you don't want to be pissed on, just don't be out in public when I'm peeing. Nope. because what he did was recklessly endanger himself. That's, first of all, recklessly endangering yourself is not typically a crime. People recklessly endanger themselves all the time, like when they go to a Golden Corral, for example, or a Taco Bell, or a Popeyes in mating season. You can't, that's not a thing. Recklessly endangering yourself, stop it. And others, he didn't recklessly endanger any other person. He didn't recklessly endanger any other person. He intentionally ended the lives of two people, and he shot one guy's bicep off. And I'm sorry that Gage Grosskreutz pegging arm is destroyed, and now he can't fist himself anymore. He has to learn how to do it with his left hand, but that was his choice. That was his choice. And listen to this. What Gage Grosskreutz did would be a war crime. It would be a war crime if he did it in armed conflict. He pretended to surrender and then pulled a gun on Kyle. It would be a war crime if he did it in armed conflict. If one of our Marines or Army soldiers did that, they could be tried in international court and go to some prison forever. Cloudfire181 says he just made the argument she wanted to be raped because she dressed like that and was out at the time. Yeah, he did. For a chance to get a legal kill. This is the biggest weird projection ever. Most people who carry aren't like, yeah, man, I hope I can shoot someone today. Almost nobody thinks that. Nobody thinks that. Because you know, if you're drawing the gun, if you're pulling that gun out, your life is in danger. The overwhelming majority of people don't want to ever draw their gun. 1, false. Curfew thing. This is just the dumbest legal reasoning I've seen in a while. 2, it doesn't matter. You don't understand because you don't want to understand. It does not matter legally at all. It doesn't change the justifiable use of deadly force question. Negligence isn't an issue. This is not how you legally test for recklessness. None of this matters. Zero, zilch, nada. You can ask stupid questions all day. They will still be stupid questions no matter what your elementary teacher told you. He says, honestly, the government calls curfew because of a riot, so let me use this chance to disobey the government to exercise my right to open carry my rifle. No, 2 different things happen. He disregarded the government order for curfew. Maybe he's on private property, allegedly with permission. That's not disregarding a curfew order. That's being out on private property with permission. The government can't stop you from being in private property the government doesn't control with permission. They can't do it. I should say on private property. They put restrictions on the whole inside private property, inside buildings things with capacity and all that stuff. Their ability to do that is questionable and rather untested during the pandemic. But that being said, he wasn't inside. He wasn't inside. Next, that's what you think drove Kyle to go to the riot so he could open carry? No, that's not what I said. He can open carry wherever he wants. That's the most ignorantly stupid thing any lawyer has said to me. But that's not what I said. That's why you're fucking dumb. And I met plenty of lawyers. Meeting lawyers doesn't mean anything. Lots of dumbasses who go to jail a lot and have a lot of public defenders meet a lot of lawyers. It doesn't mean shit. I met a lot of lawyers too. I've probably met more than you because I went to school with a whole bunch of them and had to deal with them all the time. I have to meet them as opposing counsel. Doesn't make me special. I met lawyers. Oh man, you met lawyers? Whoa. Watch out. Your dick is getting in the way of me walking. Jesus Christ. I guess not any as smugly stupid as you. And he says, point 1, wrong. Curfew laws prevent you from lawfully being where the government tells you not to be. Well, unless they're unjust, but even accepting that premise is true. So no, a curfew means you don't have the right to even be there. Bear arms and open carry at home. You not having a right to be somewhere does not similarly obviate your right to carry where you are. Those are two distinct rights. And one being mitigated doesn't negate the other. Drummer TQP says, does that mean that you are one of said dumbass pedophile lawyers because you're a grown man with sexual desire for a 17-year-old boy? Who has sexual desire for a 17-year-old boy? Jesus Christ. I find males to be repulsive. What are you talking about? Okay, so then this is my... I have 2 more replies left. You are certainly an expert on stupid, I said to him. Point 2, his intent goes a long way. It may not matter to biased gun cultist defense lawyers like yourself, but it will matter to the state and the jury. Well, you've made up his intent. The state has to prove his intent. And more importantly to this weirdo, the state isn't even arguing this. This isn't part of their case. That's what I tried to say to this guy years ago. Now it feels like the state isn't making this case against Kyle. Only Simon Says, a dumbass in the chat with a legal theory that the state doesn't even agree with. And the state is wrong in this case. The state is wrong. No one agrees with this interpretation. Insert clever name here says, I've spoken with a lawyer once or twice, and that makes me an expert on law stuff. Yes. All right. It won't matter to the state and jury because the state isn't asking these questions and the jury won't hear them. Just wait and see. He says, yeah, well, talking to people who defend Kyle's actions gave me plenty of exposure to your kind of stupid. Oh, great comeback, dummy. So my response is, I'm sorry that you're retarded. I'm sorry that you're retarded. I don't know what else to say at this point. I may be stupid, but at least... You're going to stop there. You miss... When you're saying that you may be something, it's 2 words. So yeah, you may be stupid. You're right. But at least I am not carrying my rifle to a riot against the will of the government, stupid. I guess. I'm pretty sure you're not stupid enough to get a rifle, right? I may be retarded, but at least I'm not going to be on trial for murder. Well, Kyle didn't think he'd be on trial for murder either. Most people on trial for murder don't ever expect to be on trial for murder. You fucking idiot. When I look at you, I ask myself, when did Flat Top from the Dick Tracy comics find a time to raise a pale-faced, big-lipped, beady-eyed son? Cheers, you gun cultist. Okay. I don't think my dad is Flat Top from the Dick Tracy movies, but maybe he is. I've met him a few times. And I haven't read anything else out of the thread. So, okay. I hope you expended this much energy on useful endeavors in your life. Prayer hands, Kitty. Look at how nice Kitty is. Define useful. Oh, Jesus Christ. There's your answer, Kitty. No. That's how he spells no. That's how he spells no. I told you guys. I told you guys the pain I was going through. All right, we have one more story, and this one will be quick. And by the way, you guys told me to stop drinking Coke and to start drinking more liquor. Oh, this is a good idea. Angry Baneling says, you didn't have to put us in pain too. You don't understand how this works. Look at this beautiful man. Here's Alex Jones. This story makes me frustrated. If you want to see one of the most politicized and unfair defamation cases there is, it's this one. It's this one. This case, Alex Jones has, you have to understand this whole case to understand how unjust this is. Let's do it this way. Newtown happened in 2012, right? Obama years. I'm still in law school. I remember Newtown. Newtown's a gut check for everybody for gun rights. It's one of those, this is one of those cases. Like all the other shootings and stuff, you know, those go by the wayside. It's like, okay, shootings are going to happen, blah, 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 gun rights, etc. Newtown was a gut check for a lot of people, myself included, because what Adam Lanza did in Newtown was an unrivaled level of evil. It was an unrivaled level of evil. That Adam Lanza would walk into a room with elementary school children and he would shoot, or Sandy Hook, not Newtown, sorry. Yeah, Sandy Hook in Newtown, Connecticut. That he would walk into a room with children in elementary school and kill them mercilessly is an abomination. Okay? So that being said, Alex Jones made some initial statements about the shooting. He said he thought it was a hoax or a false flag. And then he walked those statements back. He did. After his initial statements about it, he walked those statements back. However, on Alex Jones's channel, he interviewed someone who still maintained the belief that it was a hoax, it was a false flag, that it were crisis actors, all the stuff. So he interviewed someone who believed that. Okay, and that is really, really important to the case. All right? Because So then this case was filed in Connecticut. Alex Jones says, I'm not from Connecticut. Connecticut doesn't have jurisdiction over me. This should be a federal case, federal court. All right. So he removes it to federal court. Then the people suing Alex Jones said, nope, this belongs in state court in Connecticut. By the way, the place that Alex Jones is least likely to get a fair trial is in state court in Connecticut. It is the least likely place. All right. They say, nope, Alex Jones should be removed to Connecticut. Now, you may be asking, how on earth is Alex Jones, a Texas resident with a Texas business, not subject to diversity jurisdiction? Because that's the whole deal, right? It was federal court under diversity jurisdiction. Sandy Hook parents are in Connecticut. Alex Jones is in Texas. InfoWars is in Texas. Those are not Connecticut. So how is Alex Jones brought into Connecticut state court? It wasn't in Connecticut. It's because the guy he interviewed, and actually not the guy he interviewed, but the guy who drove the guy who was interviewed is from Connecticut and lives in Connecticut. Not the interviewed guy, not Alex Jones, but the guy who drove the guy Alex Jones interviewed is in Connecticut. And they sued Alex Jones, they sued the guy Alex Jones interviewed, and they sued the driver. The driver who they called an employee of the guy Alex interviewed. All right? When you start to understand like how ridiculous it is to destroy diversity jurisdiction based on baseless claims against the driver as an agent of the guy Alex interviewed, it becomes really, really ridiculous. That's how I have to lay out the extreme stretch. I see that's a bit of a stretch. That's a stretch. Blah, 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 blah. Yes, it is a stretch. It's a massive stretch. And because of that, that's how they get Alex Jones into state court in Connecticut. That's ridiculous. That's why they appealed this to the... Well, it's not why they've appealed this. So this is different. Jones is fighting a Connecticut court sanction in a defamation lawsuit brought by relatives of some of the victims of the Sandy Hook Elementary School shooting. Let's see what this NBC News article says about it. U.S. Supreme Court on Monday declined to hear an appeal by InfoWars host and conspiracy theorist Alex Jones, who is fighting a Connecticut court sanction in a defamation lawsuit brought by relatives of some of the victims of the Sandy Hook Elementary School shooting. Jones was penalized in 2019 by the trial court judge for an angry outburst on his web show against an attorney for the relatives and for violating numerous orders to turn over documents to the family's lawyers. Judge Barbara Bellis barred Jones from filing a motion to dismiss the case. Are you fucking kidding me? She barred him from filing a motion to dismiss. Oh, okay. He's definitely going to get a fair shake, which remains pending, and said she would order Jones to pay some of the family's legal fees. Jones argued he should not have been sanctioned for exercising his free speech rights. He went on his show and said something about the case. The Connecticut Supreme Court upheld Bellis's ruling last year. The families and an FBI agent who responded to the shooting, which left 20 first graders and 6 educators dead, are suing Jones and his show over claims that the massacre was a hoax. Claims, by the way, that Jones has retracted. Family said they had been subjected to harassment and death threats from Jones's followers because of the hoax conspiracy. Jones, whose show is based in Austin, Texas, has since said he believes the shooting occurred. The U.S. Supreme Court turned down Jones's request to hear his appeal without comment. Jones's attorney, Norman Pattis, called the court's decision a disappointment. Judge Bellis and the Connecticut Supreme Court asserted frightening and standardless power over the extrajudicial statements of the litigants. Pattis said in an email to the Associated Press, Mr. Jones never threatened anyone. Had he done so, he would have been charged with a crime. We are inching our way case by case towards a toothless, politically correct First Amendment. Joshua Koskoff, a lawyer for the Sandy Hook family, said Jones deserved to be sanctioned for his threatening comments on the show. The families are eager to resume their case and to hold Mr. Jones and his financial network accountable for their actions. His financial network, by the way. Koskoff said in a statement, from the beginning, our goal has been to prevent future victims of mass shootings from being preyed on by opportunists. How are these people preyed on by Alex Jones? He's expressed an opinion. He's expressed an opinion in a public forum about a public event. You have the right to believe that Sandy Hook didn't happen, by the way. I believe that Sandy Hook happened. I don't buy the crisis actor thing. I don't buy the false flag thing. Like you can. I don't care. I'm not going to tell you what's right and wrong. Me, I don't buy it. I've examined the evidence to my satisfaction. I've made my opinion on it. My opinion is that it occurred, that it was awful, all of those things. If you come to a different conclusion, I won't hate you. I don't care. You can make up your own mind. And it's one, I don't talk about it. Again, you can make up your own mind on it. I'm not here to influence you. I'm giving you my opinion. My opinion, of course, is irrelevant to any of this. Doesn't matter. Okay? That being said, you have the right to make whatever opinion you want. That's what matters here. Your opinion doesn't matter. My opinion doesn't matter. We have a right to those opinions. That's what matters. But Alex Jones apparently doesn't. More importantly, Alex Jones is not allowed to interview a guest that does, because that's the whole reason that Alex Jones is in Connecticut court, by the way. This should be in federal court. That's the main issue, is that this should be in federal court. And the whole reason that Alex Jones is not in federal court is because of the opinions of someone else. And that's real bullshit. The sanction came after Jones on InfoWars in 2019 accused an attorney for the families, Christopher Matei, of planting child pornography that was found in email metadata files that Jones turned over to Sandy Hook family's lawyers. Pattis has said the pornography was in emails sent to Jones that were never opened. This is a really interesting story, by the way. Really interesting story. Jones had emails that he sent over to the lawyers as part of the discovery request. Those emails had child pornography in the metadata or something like that. And they had never been open. So Jones had never looked at the emails or anything like that. They could check that. They'd never been open. But he accused the other lawyer on his show of saying that this happened. And somehow that amounts to a sanctionable threat? I don't get it. You're trying to set me up with child porn, Jones said on the show. $1 million, you little gang members. $1 million to put your head on a pike. This isn't a threat. Again, this judge is imposing her opinion on something. This isn't a threat. Threats have to be specific. Jones showed a photo of Matei, a former federal prosecutor, and said, "I'm done. Total war. You want it. You got it. Not a threat." This is an idiom. Jones added $1 million when they are convicted. The bounty is out. They're going to get you. They're going to get your blank, you little dirtbag. 1 million blank. It's out on your blank. I don't know what these expletives are. I thought Jones didn't swear, so I don't know what these are. This could maybe be straying into the threat, but I don't think so. I still don't think so. It's just shocking. It's hyperbolic. I don't know that it rises to a criminal threat. What's the criminal act that they're threatening? What is this? $1 million when they are convicted? When who's convicted? The bounty is out. They're going to get your blank, you little dirtbag, 1 million blank. They're going to get your what, you little dirtbag. That's not a threat. That's not an explicit crime. 1 million. It's out on your probably ass. The Connecticut Supreme Court said the sanctions against Jones did not run afoul of the First Amendment because they were imposed due to speech that was an imminent and likely threat to the administration of justice. Were they? I don't think so. Chief Justice Richard Robinson wrote, "Language evoking threats of physical harm is not tolerable." What threat of physical harm did Alex put in these statements? This is the hard part about this. This is why this case should have gone maybe to the Supreme Court, is what threat of physical harm? This is why First Amendment protections need to exist on speech. What threat of physical harm is there? By the way, someone getting your ass is not a physical threat. What threat of physical harm is getting an ass? Getting ass typically means having sexual relations with someone. Give me some ass. That means I'm going to go have sex. That's what that means. That's the idiom. And that's why we don't prosecute idioms, for example. $1 million. It's out on your ass. 1 million what? $1 million when they are convicted? Okay. When they're convicted. Are they convicted? Who's convicted? The families are suing Jones, InfoWars, and others for defamation and infliction of emotional distress. They are seeking damages that have yet to be determined. Certain individuals have persistently perpetuated a monstrous, unspeakable lie that the Sandy Hook shooting was staged. Families who lost loved ones that day are actors who faked their relatives' death, the lawsuit says. Sue called Jones the most prolific amongst these fabricators, despite him not believing the shooting was a hoax. Despite him not believing the shooting was a hoax. And alleged Jones has made tens of millions of dollars a year employing false narratives. One, who cares? Who cares? So does CNN, so does NBC, so does NPR. All of these motherfuckers make tens of millions of dollars a year employing false narratives. Maybe I should switch to false narratives. It might be more lucrative than true narratives. I don't know. But lots of people, that's fine. You can make millions of dollars a year employing false narratives. That's okay. That's okay for you to do. Nothing is wrong with this. People do it every day. Jones's previous lawyer had argued that comments on his show about the shooting being a hoax were protected by free speech rights, and Jones allowed others to state their opinions on the massacre was fake because his is a proponent of free and open debate. What is with these wording choices? Sandy Hook families also sued Jones and others for defamation in other states related to the hoax conspiracy. In one of the lawsuits, a Texas judge in 2019 ordered Jones to pay $100,000 in legal fees and refused to dismiss the suit. And a jury in Wisconsin awarded $450,000 to one of the parents in the lawsuit against conspiracy theorist writers, not including Jones, who claimed the massacre never happened. So there you go. Free speech in this country doesn't exist, apparently. I don't know. Anyway, the Supreme Court refusing to hear this is a mess. But they have lots of reasons not to hear it. They're allowing Connecticut to define its own threat law. But they really should be taking this case and saying, nope. First Amendment says we get to have opinions, and threats, because some judge says they're a threat, isn't actually a threat. We have to carefully test this. All right. It's way late. Let's do super chats. Let's end the show. By the way, I'm going to read all of the super chats and justice chats that have come in. Thank you so much for hanging out. If you do leave during this segment, know that I appreciate every single time you show up. You guys make my day. It's really great to see the interaction. Love hanging out with you. We'll be back at home tomorrow. Uncivil Law and I are going to get trashed and talk legal issues. That'll be a very, very stupid show. It'll be great. So do that. There's Wednesday. Tomorrow's Tuesday. Wednesday, I will be on Midnight's Edge in the morning, 11 a.m. And then I'll be on my show in the evening, 11 p.m. I will hopefully have some short videos coming out in the meantime. Expect an increase in short videos to come out over the next couple days and weeks as we get back into the habit of that now that I'm off vacation. Okay, let's do these. Uncivil Law says, still going strong, you weak pansy. Yeah. No one knows how much you've drank. No one knows. Knight of Hope says, it makes total sense in context of the fact that we live in a non-functioning fascist shithole like Venezuela or China. Whatever they want to do goes. Welcome to democracy, everybody. What are civil rights even? You don't need them, you pasty white bigot. Bad Dragonite says, saw Godzilla vs. Kong earlier. Pretty good movie. Big ups to the camera guy risking his life to film that stuff, though. Like, dang. Knight of Hope says, I would boycott the most egregious actors if I thought that boycotts would work. At this point, pretty much everything is on the table. We should be trying to save the society however we can. It's just not many of the measures left to do anything. Look, again, I didn't buy the Coke. I actually don't. I don't boycott anything, but I don't really buy Coke. I don't know who owns Crush. I buy Crush. I sometimes buy Canada Dry Ginger Ale. I buy Propel. Those may be owned by Coke. I haven't researched it. I buy products that I like. Whoever makes them. Sometimes statements will cause me not to buy something from a person. It's not a boycott. Like, I'm not actively not buying it. It just will reduce my particular taste towards a brand. Like, for example, Blizzard. Since Blizzard made their when they banned the guy for saying free Hong Kong, I stopped playing Diablo 3. It wasn't conscious. I just didn't want to. I want to play Diablo 2 remastered. I do. And I may actually, engage in that. Even though I'm annoyed with Blizzard, I may play Diablo 2 remastered. Because I don't really get into boycotts. Because if I tried to reason through boycotting somebody, I've got to be consistent and boycott everybody. And most companies disagree with me politically. That's just how it is. But that's me. That's me. You do what you want. Cerno says, I think the core of the problem isn't really the platforms. What does every alt tech site have problems with? The banks. We need to force non-discrimination onto the banks. I agree. And Thomas is making good arguments for how to do that as well. Cerno says, I think before we tinker with platforms, we need to make Visa and MasterCard into common carriers. I agree. Everybody should be able to transact business. They're essentially a duopoly. This is why we need an untraceable cryptocurrency. These credit card companies are acting like a shadow government. Night of Hope says, say every social media company in Google picked up and went to China, and China decided to just keep them as they are, mostly blocked in China, but allow them to continue to operate as a mechanism against America's interests. How could we deal with them then? I don't know. Malik says, in other words, if a person gets in a fight and suddenly regrets it and makes a solid attempt to escape, it's self-defense if the people chasing him and giving him reasonable fear for his life, and that's being generous, saying Rittenhouse started it. Yes, correct. Night of Hope says, Simon Says is a known activist troll. Dude's been around on YouTube pretty much as long as I've been on it and has never done anything except shovel leftist horse shit onto people's comment sections, but he's an agent of the CCP or Democrat Party. I've never seen him. Coca-Cola flavor engineer says, thank you for not boycotting our product, Mr. Ricada. We work hard to ensure quality flavor. A key component of the greater taste comes from natural flavors derived from products from the abortion aftermarket. Buy a crisp, delicious Coke product today. Thank you, flavor engineer. Thank you, you fucking asshole. The Night of Hope says, with continually less educated, more motivated generations of morons taking roles in government and the judicial system, it's a wonder to me that our legal system works at all. As much as they screw up, this all seems too complex for modern people. Silky Johnson says, I had a theory that Kyle Rittenhouse was a time traveler, and the Simon Says just confirmed it for me. Like Sam Beckett, he will make right what once was wrong and hope that his next leap will be the leap home. Leaping into commies will get an oh boy. Joseph, Night of Hope says, hey, it bears mentioning that a riot occurring somewhere means you can't go there, or else rioters get to determine if you can stand around and protect your own property or not. Kyle didn't want the riot. Neither did anybody else. Riot somewhere else, dicks. Mexican Man and Cheese says, if I was a supervillain, I would start releasing large numbers of hungry wolves into cities. Maybe that blast from the past will remind people why they need to be armed. Probably not, though. They're gang infested and still want to disarm themselves. Heinrich says, uncivil law and you should have a stream with Louis Rossman on the right to repair movement. Louis has already appeared on Uncivil Law's channel before, and he would be an interesting guest to have for sure. Helps. He's a down-to-earth kind of guy. I'd love to talk to Louis, and Uncivil is awesome for getting him on the show. Very, very cool. I'm jealous. Casually Obsessed says, sent you an email. You said before that you're bad at checking emails, so take some. Totally not bribe money with a reminder to check it later. Okay. Nick Ricada says, hey guys, I just want to be honest here for a moment. Cake donuts are the best kind, made in small town America, white bakeries. You fucking, God, I hate you. Why would you do that? Bad Dragonite says, what seems worse, cake donuts or Switzerland's authentic American frozen hot dog pizza burgers? You know what? Minecraft yourself. Fact says, my name is Simon Says, and I asked my wife's boyfriend, aka Big Daddy Government, if she can peg me every night. Wolfgang Deo says, the only thing I see that makes you think that Chauvin is guilty of something when watching the video is that someone died, and that you hold a cop and Chauvin as the same entity. Cops are entities of the state. Chauvin was filling it. I mean, it's not just that. It's the fact that he kneeled on him, and to me, it looks like on his neck for a significant chunk for a significant amount of time. Maybe longer than the manual says you should do it. It's not just that he died, it's how he died that makes me think that maybe something's wrong. Maybe something's not wrong by the law. And if, let me preface this very specifically. If what Chauvin did was legally justified, okay? And I'm willing to entertain that. I'm willing to have Chauvin walk if that's what it takes. If he's legally justified in doing what he did, he should not go to prison for a single day. Okay? I'm with it. I have no dog in this hunt. I don't care if Chauvin goes to prison ever. He's presumed innocent in my eyes. I look at it. I think there might be a crime there. I'm willing to be wrong on that. But just because I think there might be a crime there doesn't mean I want him to go to prison unjustly. Okay? This is a weird thing about how I look at stuff, maybe, or how we're supposed to look at stuff. I look at things and I say, that looks wrong, but I want a jury to figure out if it was wrong. Okay. And I want a good jury and a fair jury. If what Chauvin did was legal, he should walk and the law should be changed. That's it. That's my opinion. And that's an okay opinion. And you can have a different opinion. I don't want any cops killing citizens if we can avoid it. That's my personal thing. I don't want the state taking life. I think there's a short circuit of due process going on. I don't want any cops to die either. I understand the use of self-defense. I get it. And I endorse it. I want every cop to go home at the end of the day. But I don't want to see cops killing citizens. So I want to reduce the amount of times that cops kill citizens as much as possible. So if what Chauvin did is legal, he should walk and have his entire life be free and clear of any problems. And then I think we should change the law. That's it. The law is the thing we can change. And if we determine as a society that, hey, something was legal now, we don't want it to be in the future, then we change the law for the future, not for the past. Okay. Nova Zero says, killdozers in Connecticut rise up. Shadows King says, uncivil is pretending to be a real drunk, but we all know that gay cowboy got like this after 1.5 twisted teas. Damn. Shadows King has called out uncivil law. Red Mage 13 says, scenario example, let's say someone hits a pedestrian in an intersection, driver ran a red light, pedestrian jaywalked, such as crossed on red. How are these classified for manslaughter? That's criminal vehicular homicide in Minnesota. Driver runs a red light. It doesn't matter that they're jaywalking. Driver goes to prison for probably 10 years. Don't do it. Pingus Pounder says, my brother was a dealer who killed over 50 people selling them fentanyl-laced heroin. They'll still plea him out for a few years, probably. Damn. That's insane. Again, I don't want people to deal drugs ever. I certainly don't want them to deal laced heroin. At the same time, I have a hard time saying someone who decided to overdose because they took too many drugs, that's the dealer's fault. Fisk, the Lombax says, this is so interesting. Makes me want to go to law school. Lol, I love learning new things. Man, yes, possibly, but prepare to pay hundreds of thousands of dollars for it. Not Atheist says, read Canvas for a Cause versus Target for a great approach to weigh private property rights against free expression, modern day town square and public forum. Laws of Universities, thank you for the donation. Gawker's Death Rattle says, Thomas has a remarkably superior grasp of the issues than most judges or indeed even young lawyers. Thomas's clerks. Let's be clear on this. Thomas's clerks, who are likely fairly recent law school graduates at the top of their class, but probably with lots of experience on social media. Thomas's clerks are writing a lot of these opinions. They're helping dramatically. And Thomas treats his clerks like family. Like literally, Clarence Thomas and his wife invite the clerks to their house. They have family dinners with his law clerks. They treat them like family. So when I'm saying that, I'm not being tongue in cheek. Justice Thomas treats their law clerk like an extension of their family. They have very good relationships with them and very personal relationships with them. His law clerks are likely very, very aptly and ably informing his opinions. And that's a good thing. That's a good thing. That's what you want to happen. Clarence Thomas is like 90 years old. I think he's in his 70s, but whatever. He's 160 years old and he can't really use social media because judges aren't out there to give opinions on cases in which they may rule and issues on which they may rule. So they basically avoid social media. So Clarence Thomas isn't on social media. He needs the help from clerks who are smart, who are aligned with him in judicial reasoning, and who have experience with him. And he respects their opinions clearly, and they respect his. And that symbiotic relationship is producing these opinions. That's good. He says, who's he got on his team prepping him thusly? Oh, damn. That's what I was saying. Lanham Law says, does the fact that the tech companies have committees and tribunals similar to government agencies mean anything? I think so. It hasn't really been legally fleshed out, but the Communications Decency Act, Lanham Law, was passed when websites literally could not review all of the content that was put on them. It was passed in 1996. AI and algorithmic review was not a thing. Think of GeoCities and Angel Fire. We're talking 1996 here. America Online. These are the companies and these are the web hosts that are existing. They did not have the ability to review all content that was put up. And we're talking about a limited number of web pages. It was a big number, but it was nowhere near the number of tweets. We know that Twitter and Facebook are able to, through AI, through massive teams of reviewers, and through algorithmic content moderation, they're able to moderate every single tweet and post within seconds. Within seconds. YouTube, live streams are different, but uploads to YouTube are processed, and before the video can even go live, YouTube is typically aware of a copyright issue, of a community guidelines issue. These things oftentimes happen before a video is even public. They are, through technology, monitoring every single piece of content that is put out. Whereas when the Communications Decency Act was passed, it was passed with the recognition that they could not. So, does the fact that they have committees and tribunals similar to government agencies mean anything? Yes and no. No, because it hasn't been tested. Yes, because it should be. Peter Venedinger, thank you for the donation. Much appreciated. Marshall says, you're telling me I don't have the right to murder for minor infractions? I thought this is America. Robert Barnes says the gimme 3 steps rule from Leonard Skinner. No 3 steps, right of self-defense. Michael Karkoska says, do you think any lying Antifa type witnesses will be a problem for Kyle when he goes to trial, especially for the first guy he shot? No, I don't think that'll be a big problem. Marshall says, oh, you're at a riot. Guess the cops can open up on you, Lamau. This guy's logic. Uncivil Law says the Supreme Court seriously broke my brain in the copyright decision over API code in Google versus Oracle. I may be having a stroke. Please help. I'll have to read it, man. I haven't looked into it. Caleb Hughes says, have you watched any of the Chauvin case? The defense seems to be doing a great job. I've watched a little bit of the defense questioning of witnesses, and I agree. They're doing a very good job. They're very competent. Whether it will be enough for Chauvin to walk is a big question. Don't know. Again, I don't care. If Chauvin's guilty, put him in jail. If Chauvin's not guilty, let him go home. I have no dog in this hunt. My opinions about the legality of things are not my moral opinions, and I frankly could care fucking less what happens to Derek Chauvin. I think people misunderstand that, and they're like, you want Chauvin to fry. I don't care. You want Chauvin to walk. I don't care. Either way, I don't. It doesn't matter to me. It's going to be a riot either way. So I don't care what happens to him. I'm not him. I'm not his friend. I'm not his dad. I'm not his lawyer. I don't care what happens to Chauvin. It's not some big political statement about whatever. It's a legal issue. May not be decided justly. Those are different things, by the way. Whether it's an important legal issue and whether it'll be decided justly are two different things. I acknowledge that. But for me, it doesn't matter, right? Like for me personally, I want to see how the law works. And then if he gets convicted, he's going to get an automatic appeal, and that'll be a very interesting fight. And he may get a mistrial because of some bullshit that happened with the settlement and all that stuff. So lots of stuff to come on Chauvin forever. S. Cybertaz says, uncivil law versus Nick Rekieta. Drinking contests are a sport to us. One shall stand, one shall fall. We'll both probably vomit. Matthew Harder says, hey, Nick, I'm a guy who has two black brothers. One says the Georgia voting bill took away voting from black communities when I merely argued it was about voter ID. What say you? Also, how was your day? Matthew Harder, my day was ultimately good, even though I was frustrated because of Simon Says, because that guy's stupid. But to answer your question, I don't believe that black people are incapable of getting IDs, and I don't know why Democrats believe that they are. Sounds racist to me. Everybody should have an ID. Everybody who is of legal age to drive or vote or anything should have an ID. Now, here's the argument. Should the state subsidize an ID? If a state wants voter ID, the state should subsidize the ID. I agree with this. I think that the state, because look, for better or worse, homeless and poor people have a right to vote. So if the state wants those people voting and to have them participate, they demand an ID. The state should provide the ID. Should have needs-based ID. This is not a problem. This is a very minimal expense for the state, by the way, to have needs-based ID. It would be a minimal expense for the state to provide a state ID for free. The fact that the state requires identification for so many things and charges us is already weird, right? You pay property taxes, you pay sales taxes, you pay gas taxes, you pay excise taxes. Why? Everybody in your state has paid more than their government ID's worth of taxes. So, to me, if the government wants you to have an ID for anything, the government should provide it. But if you want to limit it to needs-based ID, then needs-based ID. After that, what's the argument? Again, what's the argument? Why are we reluctant to require identification to vote? And why do Democrats think that black people can't get ID? It's beyond me. I don't understand it. Matthew Harder says, Nick, what's the best 3 Final Fantasy games? Me, 6, 7, and 9. I will say 6, 7, and Tactics. I love me some Final Fantasy Tactics. That game was legit. I never played 9. Wasn't a fan of 8. 10 looked really gay. I'm discounting 11 and 14, even though I don't think they're the best anyway. I discount them and don't care. 6, 9, and Tactics. DCV Titan says, we need to fund an anime. I can't believe brains on the internet are this smooth and just animate the reading of posts like these. That's good. Nick Naylor says, did you wash your faux cabinets with warm soapy water? You motherfucker. Oh shit, I missed this one. Albedo says, would you say it's negligent to get snowed in a cabin where there's only Fireball for booze? Yes. Yes, I'm so sorry I missed that chat. Yes. Does anybody know, is Final Fantasy Tactics available for the Switch? Because I have a Switch Lite that I take on the plane. I would love to play some fucking Final Fantasy Tactics. I was playing it on my PlayStation Vita, I think. Not a Vita. PSP. I didn't have a Vita. I had a PSP. I think I was playing it on there last. Is it on the Switch? Is Tactics on the Switch? Only on a phone? I don't want to play it on a phone. I hate phone games. Damn it. Mikey P78. I have a Switch Lite because I have 2 Switches for my kids, but I have Switch Lite, so that they don't ever want to touch it. This is baffling to me. Final Fantasy Tactics would be great on the Switch. So would Symphony of the Night. Symphony of the Night. Look, I get that they have that other game, Bloodstained or whatever. Put Symphony of the Night on Switch. Put Final Fantasy Tactics on Switch. What the fuck is wrong with you? God, I hate these people. S. Cybertaz says, Simple Simon leered at the pie man who is roughly breeding his wife. It's okay, honey. He paid me the money. I'm having the time of my life. Phoenix Lord Asserman says, open carry is a de-escalation tactic. It tells people, don't mess with me because I can and will defend myself if I have to. Kyle did nothing wrong. I agree. Kyle did nothing wrong. Angry Baneling says, I'm going to find you and confiscate all your liquor if you don't stop this balls only nonsense. Hashtag no balls for the win. Stop it. You stop that. Angry Baneling, wanting a giant penis without balls is weird and gay. Can't believe you. Wolfgang Deo says, the riots were more insurgency than standing up. I agree. They have Bravely Default, which is, I'm tired of spiritual successors. I don't want a spiritual successor. Tactics was good. I don't want a spiritual successor ever. Uncivil Law says, Nick is the greatest internet lawyer of us all, and I only hope to live up to his example of scholarship, wit, and repose. Oh my God. What happened? How much is this man drinking? Should we send a wellness check to Uncivil? Holy Jesus. Poor guy. Half-eaten Hooker says presidents can be changed during any trial. So the evolution of law happens currently. Yeah, in some ways it's possible. If Trump had won that case, Supreme Court might have taken it. Diamond Duck, I thought I was going to get to Orlando while I was down here, and I didn't. I was hoping to pop into Kendra's office, but I wasn't in Orlando. Don Face says, would it be reasonable to say the crowd of onlookers created a situation of chaos interfering with his ability to perform his duties, effectively making the bystanders responsible for Floyd's death? 1, maybe. 2, no. The bystanders are not responsible for Floyd's death. However, one of the defense's arguments is likely going to be that the noise of the crowd, the adrenaline of Derek Chauvin, made it impossible for him to keep track of how long he was on someone's neck or shoulder or back or whatever it was. That the idea that he would have a running tally of exactly how much time he spent up there, and that he would have been able to reasonably, under the circumstances, assess how long he was kneeling is nonsense. And that nobody could be expected to do that. That's likely part of the argument. So 1, yes, I think they will argue that the crowd exacerbated the problem. 2, they can't put the liability on the crowd. So there you go. 200 Watt Studio says, Nick, are we sure that Simon Says is not Ron Toye? No. Jason of the Great Awakening says, where is this gun cult and where do I sign up? It's not at the NRA. It's at the Second Amendment Foundation. JMH016 says, Kyle might be stupid for being on trial for murder, but at least he's still alive. And that's the thing. Look, if you live through a self-defense encounter because you had to kill someone, you're going to be on trial a lot of times. That sucks, but it's better than being fucking dead. Jason of the Great Awakening says, MK Ultra and Big Pharma needed to be ended. Rhinoceros Rex says, cheers to the struggle of arguing with idiots. Question, dealing with someone in real IRL who's of the mindset the news doesn't lie, is it worth engaging? No, just peacefully ignore them. Like, you're not going to change their mind. Eventually, they'll be red pilled on it. Jason the Great Awakening says, how can Jones be threatening? He's like the same height as Ethan Ralph. Coincidence? Damn. Mr. Bentham says, yes, Nick. How can we be sure that you use the right type of soap? What was the temperature of the water? How frothy was this soapy water you claim to have used? You know, Uncivil Law says, still going strong, you weak pansy. Politikill says, your country is becoming faker than Australia and much gayer. Impossible. Architect of Fate says, my name is Nick Ricada and I love cake donuts more than raised donuts. They remind me of Ron's glazed prolapse. Delicious. Jonathan Taylor says, get Deviant Olem on for a firearms and physical security discussion. He also has a ghost gunner you may be able to borrow. He has great YouTube talks. I want Defense Distributed to send me a ghost gunner to do a show and to mill out a lower with it. Gerbrecht says, cake donuts are every breath, every day. Every day before cake donuts, they're degenerate. Andrew War Snowboard says, what if there was such a thing as a pie donut? Speaking of pie, back Rainbow Brute by Uncle Ethan Van Sciver. Jason the Great Awakening says, you are a zookeeper and your huge gorilla becomes deranged and endangers the surrounding people. Okay. Rekka Wronghouse says, I saved $5 off my pizza, so take my shekels. You do great work, my dude, in your evil lawyer voice. Drink Coke. Tasty abortion flavor. No one important says, an FF Tactics fan, my man. I liked the game. I had a lot of fun. Jeremy Griffin says, play Mechanicus if you like tactics. I have Mechanicus. I do want to play it. Got to find time. Kidda says, Final Fantasy Tactics isn't, but several Disgaea games and the Mercenary Wing Saga are. Did you guys play Vandal Hearts? Vandal Hearts on the PlayStation 1? Damn, that game was fun. I enjoyed Vandal Hearts like crazy. Fun fucking game. Very similar games. You love them. Also try the Project Triangle tech demo. Vandal Hearts was awesome. 200 Watt Studio says, Nick, play Flight Simulator on the plane home. No. Samurai Knight says, they remaking Final Fantasy Tactics as a new IP like Bravely Default was to classic Final Fantasy. Cerno says, I don't think we should repeal 230, as that would essentially mandate AI moderation, which smaller sites cannot do. We should not hold smaller sites responsible for the things that big sites would pick up using their AI tech. I agree. But by the way, that's what the big tech sites want. They want to change significantly 230 to be something they can comply with and their competition can't. Cerno says, I'm glad Google won that lawsuit. Copyright has gone way too far. I get its necessity, but it has become overbearing and borderline authoritarian. Cody Duffin says, you're wrong. The only Final Fantasy is 4. Okay. Bad Dragon Knight says, all 3 Final Fantasy Tactics games would be great on Switch. Fun fact, Final Fantasy 12 takes place in the same world as Tactics. So does Vagrant Story on the PS1. 9 is great, in my opinion. It's on Switch. Okay. All right, guys. 200 Watt Studio says, you know who else washes their figures and parts in sudsy water? Monica and Ron. I have a lot of ways to hate you, 200 Watt Studio. Okay, guys. I gotta go. This has gone on really long. I love it. It's been a lot of fun. I gotta be up in 5 hours to get ready to fly home. I'll see you guys tomorrow night with Uncivil Law. Apparently, we're going to have a drinking contest, which is a stupid plan, but I've agreed to it, so we're going to do it. We'll figure out some rules. See you then. Bad Dragonite says, Pepsi Man shakes his head disapprovingly. You know, if Pepsi tasted better, that would matter, but it doesn't. All right, guys, have a good night. Peace. Peace.
drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lafroig. The spirits flow as the ones who get unemployed. So pour out a glass for the deposed on Twitter as we hear lost-plaining tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the